Yeah, yes.
Okay, no problem. I understand.
Hey, Judge Manning.
Yes, ma'am.
Hey, I just wanted to tell you everything went great today at Prelim.
Nice.
All of them.
100%.
100% attended.
I think maybe that one phone call helped.
One call, that's all. You definitely, whatever you did, it moved it for real. Everybody, everything went. No resets, no nothing.
Was it all from the same agency?
No. It actually wasn't. We had a City of South Fulton detective earlier in the AM.
Okay, but the other agency, they all showed up.
Yes.
Fantastic.
Everybody. And they got through in good time too. And they even had a couple of more difficult cases and still got done in good time for both calendars.
Fantastic.
You are magical.
I got a little pull every now and then. Okay, gentlemen that are in the booth, everybody, I want you to pay attention. Don't twist your hair. Don't bite your fingernails. Don't turn around. Don't spin around in your seat. Please pay attention. Why should I pay attention, Judge? Because everything I say today is about you. Today, this is a you problem. This is not your lawyer's problem. This is not your mother's problem, your girlfriend's problem, your daddy's problem, your auntie's problem, or anybody. Everything today is a you problem. So you need to pay attention. Do not get up and walk out of the booth. The only way you should turn around and check is if it's called for meds and you need to get your meds, then please, by all means, get your meds. If I call your name or if I call one person's name and you know, well, gosh, that guy's right behind me, he needs to go next. No, you go first and I'll call his name later. So you stay in the booth. Do not walk out. Don't put your head down. Don't try to fix your hair. Okay? This isn't the salon. This isn't the barbershop. Now, all of your lawyers are going to email you copies of the order once they're done. Sorry, they're going to mail it to you. But if you have left the jail, you're not going to get it. So what you need to do is reach out to your lawyer once you make bond and say, lawyer friendly, I need copies of my bond conditions, because your bond conditions are going to sound something like no drugs, no alcohol, no weapons, ankle monitor, paid for by the county, 24-hour curfew, stay away, no further contact. And you need to know what to do so that you don't get your bond revoked. Today is only about bond, and everybody here has the right to remain silent. These lawyers on here do not want you to talk. There's absolutely nothing that you need to say. When I call your name, wave your hand. I know in Cobb County you're handcuffed, so if you just wave your hand up as best you can so that I know you're there. I may ask a question, are you still going to live at this address? Just give me a thumbs up or a thumbs down. That's all I need. Your lawyers will get in touch with you tomorrow or Monday, and they'll talk to you about anything else, but they're not going to have a conversation with you today after what I say, because they have more people to get to. So stay in your booths. Once I finish with you, I'm going to tell you to go ahead and leave the booth so that whoever's next can come in. So everybody sit up, pay attention, pull that door closed behind you so that you can hear what I have to say. All right, we're going to start with Ernest Cook, Miss Pinto. Bostic.
Yes, Judge.
We got Bostic back. It's a good day. We got Bostic back. All right. It is, I sent you the rotation too, Bostic. It's 22 CP 214372. Ernest Cook, 98 days without indictment. There is a $5,000 split bond for possession of firearm by a convicted felon and pedestrian in roadway. Rob.
Judge, in regards to Ernest Cook, a prior arrest, pre-arrest for probation violation conviction is a 2016 theft by receiving stolen property. Nothing further.
All right, go ahead, Miss Pinto.
Thank you, Judge. Mr. Cook is 23 years old. If released, he would reside on Mableton Parkway in Mableton, Georgia. That's where he lives with his brother, his brother's kids, and their mom. He, at time of arrest, he was working at Bellina's as a chef. It's a restaurant in Ponce City Market. He was there for 8 months, or I'm sorry, that was right before his arrest. Previous to that, he was working at Poly Air Warehouse. He went to the 12th grade of high school. He did try to sign up for the jail GED program. but for whatever reason, he never got to start that. And then they moved him over to ACDC. He is not on probation. He only has one conviction. Judge, he's been in 98 days. He's currently being held on a $5,000 bond for pedestrian and roadway. So I would ask the court to set a UJR on that charge. He is not able to pay any type of monetary bond.
It's kind of my guess, Mr. White, that this was a mistake by this judge because they gave a UJR to possession of a firearm by a convicted felon, which is a big old no-no, and 5,000 on the pedestrian roadway. Looks like it's probably should have been flipped. But go ahead, Mr. White.
That would be my guess as well, is that the judge did not intend to UJR something they can't and put a $5,000 bond on a misdemeanor. Judge, it is the state's position that a $5,000 is certainly more than reasonable for a felon in possession. And I didn't hear anything that was a material change in circumstances for Mr. Cook. At this time, Judge, the state would oppose any reduction in the bond.
Right. No drugs.
If I could just respond, Judge. I mean, he's been incarcerated 98 days. He hasn't had a prelim. This is his first bond hearing. I mean, we've tried to change his circumstances, but we certainly have not been successful. So we would ask for a reduction.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 3202 Martin Luther King Jr. Drive Southwest. And you live in Mapleton, sir, so stay out of Fulton County unless you're here for court or to see your lawyer. That's the only reason you're going to come back to Fulton County. You understand? Shook his head, yep, give a thumbs up, gave a thumbs up for the affirmative. He is not going to come back to Fulton County. 4,000 on count 1, UJR through the jail on count 2. So I just flipped it and made it correct since you shouldn't get a UJR for possession of firearm. Sir, you can't be around a firearm, okay? Best of luck to you, sir. Thank you. All right, so we'll go to...
Can I
Yes.
make a brief announcement? I apologize.
Yes, ma'am.
The ADA, it looks like Marshall Hodge is on position 13 and 17. He emailed me and asked to hold for his report. He's still in Judge Barwick. So for position ADA Marshall Hodge, I think he's handling position 13 and 17. He is
Okay.
finishing up in Judge Barwick, and he said he'd hold for his report.
Okay. All right. Sounds good. All right. This will be Oliver Binion on here. It's position 6. The Oliver Binion, wave your hand. All right. 22 CP 214148, 109 days without indictment. There is a $20,000 split bond. 109 days without indictment. Criminal attempt to commit a felony. Criminal attempt to commit a felony. Possession of firearm by a convicted felon. Willful obstruction misdemeanor. Loitering and prowling. Free trial.
10 prior arrests, prior criminal trespass, PI in 2020, PI in 2022, first offender in 2018 for aggravated battery of a law enforcement officer. Nothing further.
Go ahead, Mr. Houston.
Yes, Your Honor. Mr. Binion is 37 years of age. The address on file is correct. He's been in Atlanta, Georgia since 1995, originally from Mississippi. Does have 3 stepchildren. Graduated from Banneker, currently unemployed, but is looking. Your Honor, we would ask for a reasonable reduction on all charges. We would defer to the court's discretion. Thank you.
All right, you gentlemen that are just now coming in here, besides the deputy sheriff up there, if you're just now coming in, make sure you stay in the booth. Don't turn around. Don't walk out. Don't do any of that. Pay attention. Don't put your hair down. Don't fix your hair. Don't mash pimples on your face. Anything like that. Just pay attention. Go ahead, Mr. White.
Judge, at this point, this defendant again is a very reasonable bond given the given his criminal history, especially his recent criminal history, and given the fact the charges that he's currently under, the state would object to any reduction in the bond amount at this time.
All right. And some of this was put through pretrial, Bostic. Is that a big no-no?
It shouldn't be through pretrial. What was put through pretrial? The misdemeanors.
Well, one of these is a criminal attempt to commit a felony. One is willful obstruction, and the other one is loitering and prowling.
What is the felony? But I guess it's fine. I guess there's because he really doesn't have a felony conviction. So he probably would have qualified for pretrial services. And the only charge on here that's not pretrial, can be pretrial, is the gun.
Is the firearm?
Yes.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons. And it's a Fairburn address you're gonna live at, sir? Thumbs up or thumbs down? All right, Fairburn, Georgia. No further contact with Doreyn James, and no further contact with Adrian, Adriene Wright, Wright. Stay away from 9545 Lakeview Road in Union City and 9527 Lakeview Road in Union City. I don't know why they did that. Okay, so you 10 on count one. I'll leave those two UJR through pretrial. Level 2. How often does that make them report?
Every 2 weeks.
All right, and then the other one, and I'll leave number 3 at 5. So I'll reduce count 1 to 10, level 3 at number 3 at 5, and I'll leave the other at UJR through pretrial level 2. Sir, you're going to need to reach out to pretrial once you get out and let them know and talk to them, because they're going to tell you exactly what you need to do. Failure to you to report to pretrial every 2 weeks will result in a bond being revoked and you sitting in jail. Best of luck to you, sir. You can leave the booth. Mr. Lowry. Thank you, sir. All right, Ms. Rosenhoover, here we go. It's Najee. I think that's right. I apologize if it's not, sir. Lowry, 22, CP 214-239, 105 days without indictment. There's no bond as of November the 26th. Possession, purchase, manufacture, distribution, sale of marijuana, possession of a firearm during the commission of or attempt to commit certain felonies, fleeing or attempting to elude, use of a firearm by a convicted felon during the commission of a crime, obstructing or hindering a person making an emergency call, failure to have license on person, failure to obey yield sign, and failure to obey traffic signs, signals, and markings. And it was 221 grams of weed. Pretrial.
Judge, in regards to Mr. Lowry, 7 prior arrests, counts of Holden Jonesboro for probation violations. He has a first offender financial transaction card theft of 2018, currently on probation. For entering auto, 10 counts out of Clayton, 8, 10, 18 for 5 years. Nothing further.
All right, go ahead, Ms. Rosenhoover. And I've got he lives in Stockbridge.
That's correct, Judge. Mr. Lowry is 23 years old. He's a lifelong Georgia resident. The Stockbridge address has been updated. That's the correct address. He would be living there with his mom. Judge, he also has a sister, brother, and an uncle here in Georgia. He's a high school graduate, and most recently he was working for various jobs through a temp agency. He was with Skyrod Auto Sales for anywhere between 5 and 6 years. And Judge, he does have some night shifts with the staffing company. So since he is legally entitled to a bond, we are asking for one not to exceed $10,000 and for it to have specific work exceptions so that he can attend those particular shifts. And Judge, these are the recommendations or requests by charge. For count 1, we're asking for $1,000, count 2, $3,000, count 3, $1,000, count 4, $3,000. And counts 5 through 8, we're asking for $500 for a total of 10. Thank you.
Go ahead, Mr. White.
Judge, the state notes that this defendant, in fact, is entitled to a bond. The state would just request that any bond that the court sets include, hang on for a second, I'm trying to relocate the include a strict no driving any motor vehicle provision, as well as a 24-hour house arrest enforced by an ankle monitor. The state would not object to a emergency medical exception to that if taken away from his home in an ambulance, in-person court appearances, and I'm not seeing that, and frankly, that he has steady employment. And I don't think that working odd jobs at the temp agency necessarily qualifies as steady employment. We'd seek that there be no employment exception. Thank you.
No drugs unless prescribed, no alcohol, no weapons. Sir, you live in Stockbridge, that's Henry County. Stay out of Fulton County. The only reason you're coming to Fulton County is court or to see your lawyer. Don't get gas, don't change a tire. Booth 3 North, booth 3. How you doing? Yeah, face this way. There you go. Appreciate you. All right. Only reason you come to Fulton County is court or to see your lawyer. You don't stop for gas, don't get a snack, don't get a flat tire. You go straight to court, straight to see your lawyer, straight home. Don't pass go, don't collect $200. Stay away from 3155 Camp Creek Parkway, which should be fine because that's in Fulton County. You're not coming back to Fulton County. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. No driving during the pendency of this case. I guess you're going to have to get somebody to bring you here to Fulton County when you come to court. 221.5 grams of weed. That's going to be $7,000. 5,000 on count 2, 3,000 on count 3, 5,000 on count 4, 5,000 on count 5. 500, 500, 500. So it's 7,000, 5,000, 3,000, 5,000, 5,000, 500, 500, 500. Got that, Miss Williams?
Yes, Your Honor.
All right. Best of luck to you, sir. You can leave the booth. Dustin Williams. Wave your hand if you're Dustin Williams. All right. Who else is out at Cobb there?
Judge, I'm not sure. Lieutenant Conklin is trying to find out now who is the other one in Cobb because we only had 2.
Okay, Dustin Williams, Miss Beck. Here we go. It's position 3, 21 CP 2044140. Excuse me, 204140. 497 days without indictment. There is a $11,000 split bond for aggravated assault against peace officer, possession of methamphetamine, fleeing or attempting to elude, and willful obstruction. Pre-trial. And before you go, hold on. Call booth 2. What's your name, sir?
Go ahead, you can talk to her.
Kitchen,
Who is it?
kitchen.
James Kitchen.
Let's see. That one. Sir, your case has been removed because you just had a bond set on you March the 2nd. Thank you, Cobb. That's it.
Thank you, Judge. I have a good evening.
You too. All right, go ahead, Busty.
Judge, 14 prior arrests in Georgia, 1 arrest for probation violation, prior 2013 purchase, manufacturing, sale, 1 FTA, first offender on a forgery, and a prior ag assault 06.
I know, Miss Beck, I know how many times you're going to say 497 days, so go ahead.
What was your bet?
Double or nothing, go ahead.
497 days without indictment, Your Honor. As a reminder, he was seen on February 2nd for a bond hearing, and Your Honor set a bond. At that time, it had only been 462 days. And you set a bond of $11,000 or a UJR to the hold. By my math, which could be incorrect because I'm not great at it, but by my math, that has been 37 days for both of his holds to have to come pick him up, in which they have not. Mr. Williams has been in for 497 days, so he cannot afford the bond of $11,000. I can go through all of the bond factors if you want, but at this point, we are asking for just a UJR to go home because it has been 497 days without indictment.
So, Ms. Beck, do you know why the holds won't come get him? Are they just misdemeanor holds, not worth coming to pick him up? Any idea?
I'm not sure, Your Honor.
Mr. White?
Judge, while I appreciate the defense counsel's passion, this court lacks authority to UJR, aggravated assault against a peace officer. Also, this was heard 37 days ago. There's been no material change in circumstance in the last 37 days. Somewhat premature to readdress bond at this point. The state would object to any change in the bond at this time. Thank you.
Your Honor, if I may.
Sure.
material change in circumstance isn't actually a factor to be considered. Additionally, it was your honor that asked for it to be put on the calendar to check in so that it wouldn't, so Mr. Williams wouldn't continue to just sit here. I don't know how much longer the state would like for him to just sit. It's been 500 days at this point. While you may not be able to do a UJR to the hold, we would consent to $500 for each charge.
I just emailed Ms. Willis with a big old, very important, I'll text her also, because this is, yeah, this is kind of bad. All right, sir. No drugs unless prescribed, no alcohol. Have we had any contact with the, by the way, excuse me, Sergeant Romero? The victim, do you know, Mr. White?
Checking, Judge.
I can tell you that at the preliminary hearing, which was in the last 2 months, he was not there he wasn't the one that testified. And at that time, they hadn't had any contact.
Okay. All right, let's see. No drugs unless prescribed, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical appearances only. Stay away from 5793 Roswell Road. Stay out of Fulton County unless you're here for court or to see your lawyer. Don't get gas. Don't stop for lunch. Don't get a flat tire. Don't stop at Chick-fil-A, Chipotle, any of your big old favorites. And also no driving during the pendency of this case. No further contact with Sergeant David Romero of Sandy Springs Police Department unless it's in his official capacity, which you shouldn't run into him in Sandy Springs because that's in Fulton County and you're not going to come to Fulton County. 5,000 on will the bail project get him out?
I don't believe so, Your Honor, because the holds are still showing, but I don't know how we can get those holds just, I don't know how it works, but again, he can't just continue to sit here waiting. So I know that the bail project will not take him.
5 on count 1, 2 on count 5, because the other 2 were, wait a minute.
UJRs.
Yeah, the methamphetamines and the, wait a minute, let's see. I got ag assault, possession of methamphetamine, fleeing or attempting to elude, and obstruction. So the fleeing and the willful obstruction, right?
Were UJRs, is that what you're asking?
UJR. Yeah.
Yes, Your Honor.
Wait, 1, 2, 3, 4. Oh, because the methamphetamine number 3 was dismissed.
Yes, Your Honor.
So really it's just $5,000, right? Wait a minute. Hold on. Oh. Yeah, because already methamphetamine and the fleeing and the obstruction is the last one, so I admit that too. So it's $7,000 total good bond, and I'm going to let you both know. I'll copy you on this other email that I sent to Miss Willis. As a matter of fact, after this, I'm going to call her this evening.
Thank you, Your Honor.
All right. Best of luck to you, sir. You can leave the booth.
Okay, Your Honor, I'm sorry.
And if a hold picks her up, sorry. So it's going to be 5,000 on the ag assault and 2,000 on the obstruction. And the others are still UJR through the jail. And no driving during the pendency case. And also he'll have 48 hours to have that ankle monitor placed on him if he's released from those holds.
Thank you, Your Honor.
Okay, thank you. Let's see. So we're waiting on ACDC to get the email. So let's see, do we have?
Your
Shall I-
Honor, excuse me, Your Honor.
Who you got there?
I got Miss Brianna White. I have a little, if we can, come on, have a seat, Brianna White.
You got Miss White and who else?
Miss White, the judge is in front of you.
Stop talking, ma'am. Who else is there? ACDC?
Where did y'all get?
Miss White, stop talking.
Oh, okay.
Deputy, who else is there besides Miss White?
Parker.
Parker. Okay. All right, Miss White, this is Miss Pinto. It's 22 CP 214361. 99 days without indictment. There is no bond on aggravated assault, battery, and 2 counts of misdemeanor willful obstruction. Pre-trial.
Multi-state offender, 1 in Michigan, 1 in Tennessee, 18 in Georgia, 2016, theft by receiving, 2019, theft by taking, took a PTI on heroin with the intent of first offender.
Hey, stop. Hold on, Bostic.
2014.
Hold on, Bostic. Miss White, what's funny? What's funny?
Oh, that wasn't me laughing.
Yeah, it was.
I thought that was Judge Pinto. Prosecutor Pinto.
Miss Pinto isn't laughing at anything. That was you laughing. Do you think I'm blind?
Now I can see. Same
Okay, well, your little square lights up yellow when saw you laughing. So what I'm going to do is I'm going to put you on mute because I don't want to hear another word from you. Start over, Bostic. Sorry, Bostic.
Okay, no problem. 1 in Michigan, 1 in Tennessee, 18 in Georgia, theft by receiving stolen property in 2016, 2019, theft by taking PTI heroin with the intent, first offender burglary 2014, currently on probation. 21 SC 179808, entering auto obstruction, sentence 12-15-21 for 5 years. Also for a simple assault on and a simple battery on a peace officer, sentence 11-8-22 for 12 months. Nothing further.
All right, Miss Pinto, if you can hold back your laughter, go ahead.
Thank you, Judge. Miss White is 28 years old. She turned 28 soon after her arrest. We do have a good mailing address for her on Terrace Court in Union City. She's resided in Georgia for 13 years. She graduated from Newton County High School, so she does have strong ties to this community. At the time of her arrest, she was working as a cashier at Checkers. She had been there for 8 months. Unfortunately, it's likely she's lost that job at this point. She also was working at Harry and Davis doing assembly work. We are, of course, Miss White is entitled to a bond. She's been incarcerated 99 days with no bond or and no preliminary hearing. We would ask for a reasonable bond for Miss White. She is indigent, and really the only way that she could bond out, Judge, is through the bail project. So we would ask for a bond not to exceed $5,000 total.
So is that mailing address? Is that where she's going to be able to live or no?
At this time, it's just a mailing address. We're working on something more stable.
Okay, go ahead, Mr. White.
That's the state would point out that this defendant has no fixed address. That in the 10 years since she has reached the age of majority, she's managed 2 felony arrests per year on average. That she has already been found to be a significant danger to the community and to her victims. Your Honor, at this time, because she is entitled to a bond, the state would request that any bond the court is inclined to set would include a 24-hour house arrest, the only exceptions being medical emergencies when she is taken away from whatever address she's actually going to stay at in an ambulance, and in-person court appearances. Judges, there is no fixed address. I'm not sure exactly how we're gonna geofence her for an ankle monitor, but then again, I'll leave that for Your Honor to solve. Thank
Ms.
you.
Pinto, are you planning on an ex parte by any chance?
Yes, Judge.
Okay. You send me that ex parte, I'll be glad to sign that. No drugs unless prescribed, no alcohol, no weapons. You must take all prescriptions that are given to you legally. No further contact with Chelsea, CHELSIA, Tarver, TARVER. Anytime you commit an alleged crime at MARTA, they suspend you or ban you from MARTA. They've already told you that upon your arrest. You got to stay away from 30 Alabama Street Southwest and stay away from all MARTA, bus stops and train stations and MARTA property. if your shoe comes untied, you're walking on the road, then you can't stop at a bus stop to tie your shoe, ma'am. You got to sit down on the corner to tie your shoe, but not on that bench. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, and medical. And you follow any recommendations and participate in any program that Ms. Pinto gets you into. You must provide an address where you'll be living to get out of jail. Ms. Pinto is going to try to get you into a program. According to this, you battered the alleged victim on the head with a horseshoe. So 15,000, 10,000, 5,000, and 5,000. 15, 10, 5, and 5. Best of luck to you, ma'am.
Judge, I'm not sure that the court can mandate that she take prescriptions.
Oh, I mean, take any if they're prescribed to her by her. Well, we hope she'll follow the recommendations and treatment. How about that? Follow the recommendations and treatment. Thank you, ma'am. So we got Winnie Parker. I'm sorry if I mispronounced that, ma'am. It's a 22 CP 214338. 100 days without indictment. There is a $25,000 good bond as of November 30th on aggravated assault, family violence, pre-trial.
7 prior arrests, 1 FTA, a simple assault, family violence in 2020, 1 arrest for probation violation on felony probation theft by receiving stolen property, sentence 5/28/19, 30 days confinement, 4 years, 35 days probation. Nothing further.
Ms. Collins, I know the event allegedly took place where at the home address. Is that where she lives still, or
Your Honor, I don't believe that maybe I should just get into my bond argument, but the address listed in the warrants, I don't think she's not living at that address anymore. Okay. Your Honor, she is 35 years old. She has been in custody now for, I believe, approximately 100 days. This is her first court hearing since her first appearance back in November. She hasn't had a preliminary hearing on this case either, and there is not one scheduled. The case remains unindicted, Your Honor. We are asking for a reduction. Our change in circumstances would be the lack of financial resources. She has been without income for 100 days. And so she doesn't have any money to put towards any bond. Her family does not have any money to put towards any bond. And so that is one of our change in circumstances. The other change in circumstance is the amount of time she's been in custody without indictment on this case or any type of movement. Your Honor, just a little bit about this case. This incident is from March 18th of 2021. So it's a fairly older case. It's my understanding from, because I have made contact with the complaining witness. I've spoken to him multiple times. We speak quite often, actually, that he does not wish to see this case prosecuted. He wants to see Ms. Parker released. It's my understanding that after this incident was reported, they continued to live with each other until the arrest. He has returned to me a signed waiver of prosecution that has been notarized. I did submit that to the DA's office, to Deputy Kenneth Hutcherson, and explain Mr. Hill's desires for the case. It's my understanding from speaking with Mr. Hill that he has also communicated to the district attorney's office that he does not want to move forward on this case. From my reading of the warrants and the police reports, there are no witnesses, there are no video recordings. It seems the evidence here is purely the statements of Mr. Hill, who is very adamant that he does not want to see this case move forward. She's been in custody now for 100 days. We're asking for a reduction, Your Honor. I believe that she only has that one felony conviction for a nonviolent offense. There was a probation matter pending. However, that matter has been taken care of as of January 20th. She received time served on that, and all that is holding her in here now is this bond that is unobtainable for her. Your Honor, we are asking if you would consider reducing this bond to $5,000 so that Ms. Parker can use the assistance of the Bell Project to be released. She's 35 years old, Your Honor. She has lived in Georgia since 2009. That's over a decade here. She does have a good address. That's 50 Mount Zion Road, Southwest, Atlanta, Georgia, 30354. She is a high school graduate, and she also attended 1 year of college for nursing, and she is a mother to a 10-year-old son. Your Honor, we are asking again if you would consider reducing this bond to $5,000, given that there has been no movement and there are no court dates upcoming for her.
All right, what says the state?
The state would note that it looks like we've been in contact with the victim, or the victim's been in contact with the state no fewer than 7 times. The state would point out that this is the same victim as was the victim of an aggravated assault by the defendant in 19 SC 172319. That was eventually dead docketed when the victim essentially refused to testify against the defendant. Judge, this defendant is a significant risk to the victim and a significant risk, as her history has shown, of intimidating the victim and or influencing his testimony, should she be released. Judge, $25,000 is a very reasonable bond considering the history of family violence between the victim and the defendant. If this defendant is released from jail, and I'm just checking to see if we have pulled the jail call records, and I don't see them, Judge, that there be a strict stay away, no contact of any kind with the victim. And I understand that the victim would like to have contact with this defendant, but the state would request no contact of any kind with the victim, stay away from the incident location. And I believe that's it, Judge.
All right.
Your Honor,
Yes.
I would just again reiterate, the victim does want contact. The victim wants to see Ms. Parker released. He does not want to see this case move forward. I think that those desires are contradictory to Ms. Parker being a threat to Mr. Hill. He clearly does not feel that way. We've heard no evidence that she has attempted to contact him while they've been in custody to influence him. And so, Your Honor, I would again, they've had ample amount of time to get this case indicted if they feel she's such a danger to him, but they have not, and it's been almost going over 100 days now.
100 days. All right. Well, sometimes I guess that's when I come in and I have to protect people. It concerns me that he was an alleged victim in another case, but no drugs unless prescribed, no alcohol, no weapons, no further contact with Keenan Hill. If he would have appeared on here tonight, it may be in a different story. Stay away from 2247 Belvedere Avenue. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment, a schedule, and the exact location you're going to be working. Ma'am, absolutely no contact with him. None. He calls you, hang up and walk away. You understand?
Yes, ma'am.
$15,000 good bond. Best of luck to you, ma'am. You can leave the booth.
And I'm just going to comment. I understand you said if he was here, but I mean, we
If I heard it
as
from him,
attorneys have a duty of confidentiality, a duty to be honest to the court. 88 White has stated the victim's intentions, and I have stated the victim's intentions.
I understand that. And for the record, it's also me who's protecting these people. It looks like there has been a rise in domestic violence crimes ending in murder, and it's not going to be on my shoulders. I can tell you that. I'm telling you to stay away from him, ma'am. Period. That's the cycle of violence as I understand it. Thank you. Thank you, ACDC. Have a good evening. Do we have Shaheem Myers? Mr. Myers. Mr. Myers, did I miss you waving your hand? All right, what about Kevin Crawford? I don't see a Kevin Crawford. You guys, if I miss somebody raising their hand, let me know. Let's see, what about Sean DeWitty? All right, there we go. Ms. Collins. It's number 2, Bostic 22 CP 211745, 198 days without bond. Without indictment. There is a $10,000 good bond on aggravated assault against a law enforcement officer when engaged in official duties, willful obstruction of a law enforcement officer by use of threats or violence, simple battery against a police officer. Free trial.
Only prior Georgia arrest, 1 in Louisiana, 4 in Colorado, 2016 criminal damage to property, and 2017 assault. Nothing further.
Go ahead, Ms. Collins.
Your Honor, Mr. DeWitty, he has been incarcerated for 198 days on this $10,000 bond that he cannot afford. Well, it was reduced to 10,000 in November, but he is still unable to afford that, Your Honor. And we are asking if you would consider a reduction in bond today. We're asking if you would consider reducing this bond to $5,000. Your Honor, he, again, 198 days. There was a prelim held 3 months ago, and the case still remains unindicted, even though probable cause has been found. Mr. DeWitty, he has turned 37 since his incarceration. He has been in Georgia now for 7 years. He does have a good mailing address. That's his father's address, 2668 Mingo Circle in Atlanta, Georgia, 30318. His father is watching via the YouTube channel, Your Honor. He does have a strong support system. He does not have any children, but he does have family here in Georgia. He has his father and he has his sister and other extended family members. He's a high school graduate, and he also has a bachelor's in interdisciplinary studies from Arizona State. He was previously on a fixed income. He was receiving SSI disability income, Your Honor. And so that goes to say that he is definitely indigent. He meets the qualifications for representation by our office, and he cannot afford any unreasonable bond or any high bond. And 10,000, understand the charges are fairly low, but it is too much for him to afford given his unique circumstances, Your Honor. And I believe under OCGA 17-6-1, you can consider a person's financial resources or lack thereof when considering bail. And I'm asking you to consider the fact that he is on a fixed income when considering whether to reduce his bond or not. Your Honor, there are some underlying MH concerns which you probably are already aware of.
Ex parte came back, right?
Yes, Your Honor, and we are proceeding.
Okay, I got you. What address is he going to be living at?
Your Honor, I believe he can live at his father's address. I've spoken to his father just recently as a few hours before this hearing. Our desires are, and what it is also Mr. DeWitty's desires, and what his family, who knows him better than I do, think is the best fit for him, is to try to get him into some type of inpatient care. That can be very difficult with mental health, as there's really not a lot of inpatient programs for mental health. But his father has been reaching out, and he has gotten connected with Grady Behavioral Health Center, and he's been speaking with a case manager there. His father is looking into getting him referred to an inpatient program that they have there. We don't have that finalized yet, but that is something that is in the works. We're just waiting to hear back from higher ups there. We've also referred this case to Behavioral Health Treatment Court, and we're still waiting to hear back from that. Your Honor, we are here today just to ask if you would consider reducing the bond to $5,000, just for purposes of judicial economy, so that when we are able to find some type of placement for him, whether it be inpatient or outpatient, with him just living at the family home and then reporting to outpatient services, that he already have a bond in place, and we may be able to seek assistance from the Bail Project. You're probably already familiar with the Bail Project, but I would reiterate that the Bail Project will not pay or assist anyone in bond unless they have a good address and they are able to confirm that address through a community member.
Okay. 3 cell, booth 3, sit down. Sit. Thank you. All right, Mr. White, go ahead.
Judge, at this time, and Your Honor, I'm sure more familiar with the case than I am. I realize that there's been a lot of time that since this defendant's arrest. However, he did spend a significant amount of time due to the in a situation due to the underlying issues that are obvious here. The state would not object to lowering the bond to $5,000. so that the bail project could make the bond when this defendant meets the requirements, the other requirements of bail bond that the bail project has. And I believe the court is familiar. He will need either a program to be released into or a stable address to be released to.
Okay.
Nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Officer Christopher Scott. Unless it's in the official capacity, no further contact with Irma, IRMA, last name SUDAH. Stay away from 2751 Donnelly Hollowell. In Atlanta, Georgia, no drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and MH treatment. You must comply with the directions of any medications and treatment. And Ms. Collins, if you get him into any sort of MH treatment, the ankle monitor interferes, let us know, okay?
I will, thank you.
And ask that the public defenders on here, and if there's any private lawyers on here, if your client has been on an ankle monitor over than a year, and there has been no offenses, please reach out to Orca, file a motion, let's get them back on here. Nobody should be on an ankle monitor for 3 years with no offenses. So, Ms. Collins, if there's anybody else in your office, anybody that you know, any other lawyers, they should not be on an ankle monitor for 3 years. I mean, that's ridiculous. All right, so make sure y'all get them on there. Okay, so since Mr. White agreed, we'll do 3,000. How about 3,500? $1,000 and then 500. 3,500, 1,000 and 500.
Thank you, Judge.
Yeah, all right, and you have to provide an address where you're going to be living, sir, to get out. Best of luck to you. You can leave the booth. Thank you, sir. All right, Ronell Anderson. All right, let's see. This is Ronell Anderson, 22 CP 214308. Is Ms. Kennebrew here?
Good evening, Your Honor. Attorney Cazzoli is here
Okay.
for Ms. Kennebrew.
All right, 101 days without indictment, aggravated assault, armed robbery, criminal attempt to commit a felony, and false imprisonment. And there's no bond, ma'am, as of 12/1. Pre-trial.
Judge, in regards to Anderson, both a state offender, 12 in Illinois, 2 in Tennessee, and 1 in Pennsylvania, 4 in Minnesota prior, 2012 theft by shoplifting, 2013 aggravated assault and shoplifting, 2016 theft by shoplifting, 2 FTAs. Nothing further.
Go ahead, Mr. Cazzoli.
Thank you, Your Honor. Ms. Anderson is 32 years old. She's been living in Georgia for the last 3 years. Her father, her sister, and her cousins are also in Georgia as well. She's a high school graduate and attended some college at Kennedy King College in Chicago. She was previously working as a hairstylist and did dance choreography as well. She has a verified address at 871 Society Circle, Southwest Atlanta, Georgia, 30331, where she lives with her sister. Your Honor, we are asking for Ms. Anderson is now statutorily entitled to a bond. We're asking for a bond not to exceed 30,000 with my apologies, 35,000 with 10 on the ag assault, 10 on the armed robbery, 10 on the false imprisonment, and 5 on the criminal attempt.
All right, Mr. White.
Just checking, Judge, to see. I don't believe that this defendant, when she was booked in, at least my notes don't have a Georgia address for her when she was booked in, but I'm just checking to make sure my notes are good.
Let's see, on the booking sheet, it says Society Circle, but I don't know what you see different.
Judge, at this time, the state would request that any bond that the court gives includes a 24-hour house arrest enforced by an ankle monitor that the only exceptions be medical emergency when carried away from her residence in an ambulance and in-court appearances, nothing further.
Your Honor, we ask that any curfew have the standard exceptions of any sort of medical care, not just ambulance, and any sort of legal proceeding, as well as Your Honor, we would ask that she be allowed to work as well. So we would just ask for the standard exceptions to a curfew.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with ALIM, last name MOMIN. You're gonna have ankle monitor paid for by the county with that 24-hour curfew, with the exception of court, lawyer, medical. That includes MH by HS if you need it. Not saying that you do need it, but just making that clear. It also work. But ma'am, you have to supply the name of your employer, proof of employment, a schedule in the exact location that you're going to be working. So if you get a job and you're doing hair again, you have to let them know. But that doesn't mean you go out in the middle of the night to work at a salon. So it's got to be reasonable hours. Please stay away from 396 Piedmont Avenue, apartment 1051. And if your address changes, ma'am, you do have to let everybody know. Okay, there's 10,000, 10,000, 5,000, 10,000. Best of luck to you, ma'am. You can leave the booth. All right, let's see. Do we have Shaheem Myers yet? Nope. What about
Yeah, I
Kevin?
think they're working on trying to get him in the booth.
Okay, what about
Okay.
Kevin Crow? Kevin,
Judge
who's talking?
Foster.
Oh, what boss? What?
I don't have Shaheem Myers and the other person name you said.
They were added. They were from resets from the February 28th.
Okay.
Let's see.
Who was the other person you said? Myers and who else?
Hold on. There was also a. Let's see.
It was somebody named who wasn't in the booth after you said Myers the first
Kevin
time.
Crawford,
That's it. Thank you.
Marcellus Nelson. All right, Ms. Pinto. This is 22 CP 210494. Aggravated assault with a deadly weapon. Oh, this is what it would have been 245 days without indictment. Oh, let me see. And there is a $8,000 good bond as of October 13th. Pre-trial.
Which defendant, Judge?
Marcellus Nelson. Would have been one on the add-on.
Okay. Marcellus Nelson. Is he on the
One? It's on the add-on calendar. He had been on the February the 23rd.
I wouldn't have those. I only had 2 add-on calendars.
Did it? You know, come back to Marcellus Nelson. You got the booking number?
Yes, because yes.
All right, 221-0050.
221-0090.
No, 0050.
Okay.
Get right back, you, Mr. Nelson. I got Levi Rivera Martinez. And Ms. Rosenhuber doesn't need an interpreter, I'm assuming, right?
That's correct, Judge.
All right. This is a position ward Bostic 22 CP 211634. 203 days without indictment, and we've got $59,000 good bond as of 11/23/22. Theft by receiving stolen property. Aggravated assault against law enforcement officer when engaged in official duty. Criminal trespass. Criminal damage to property 2nd degree. Criminal damage to property 2nd degree. Willful obstruction misdemeanor. No insurance. Attempting to misrepresent tag. Failure to yield right of way of emergency vehicle. Reckless driving. Failure to obey traffic signal or light. Driving hit and run. And leaving and attempting to elude. Pre-trial.
No prior Georgia arrests, 3 arrests in North Carolina, and had an ICE hold. Nothing further.
All right, go ahead.
Thank you, Judge.
I may have called out a couple of Miss Rosenhuber, so I will definitely check that were dismissed that seem to be on this calendar. So I'll make sure that I get those right. Go ahead.
Thank you, Judge. Mr. Rivera Martinez is 29 years old. The address that's on file for him is where he and his uncle reside. It's in Cumming, Georgia. Judge, as you heard, he does currently have an ICE hold, but he has lived here in Georgia for the past 2 years prior to his arrest. He made it to the 11th grade and was doing pool construction work. Judge, I do want to note we had this preliminary hearing in November, and so far there's been no movement on this case. It remains unindicted for the past 203 days. And given those circumstances, we are asking for a fairly significant reduction, almost a little over half. And I can go by the calendar, Judge, or I can go by the bond order with my recommendations. Which would you prefer?
I think the things that are on the calendar actually right now that I look through it. So if you want to go by the calendar, unless you think some of them.
I can do that, Judge.
Okay, yeah, 'cause I think it's right. Go ahead.
Count one, we're requesting 3,000. Count two, 6,000. Counts 3 and 4, 1.5 thousand. Count 5, 3,000. Count, or the next count's 500, 500, and 500. And then I've lost count, but 6,000, 500, 6,000, and 6,000 for a total of a $35,000 bond, reduced from the 59. Thank you.
All right, Mr. White.
Judge, this state would note that this defendant's ties to the nation are tenuous at best, and that he is a significant risk of simply disappearing when he is eventually released from custody. Also, the state would note that there has been no change in circumstance since the November 23rd, 2022 preliminary hearing and bond. The state would object to any change in the bond at this time. So I don't think further.
So Mr. White, let's say he can make this bond. I mean, what condition do you want on it to make sure that he, I mean, I can't control ICE, but what condition would you want on there? Because on here, I think it said
if he makes this bond, he's going to be in ICE custody, and ankle monitor and all that is going to come off. I don't think there's any condition that this court could set that would really mean anything to.
I mean, if they don't pick him up, I think on here it said he must. They had a condition that he must reside in Cumming, Georgia. I don't know how often ICE is coming to get people.
Judge, if I may, it's well within the state's control to indict this case if that's their concern. And they have had an opportunity to, and it's been 203 days and nothing has happened on this case.
Whoa. Booth 5 North. Keep your shirt on, step out and change shirts. We don't strip down naked in the courtroom. That's not what we do. All right. Well, here's what we'll do. Also, all right. No drugs unless prescribed, no alcohol, no weapons, no driving during the pendency of this case. Upon release, you have to reside at 1885 Valley Way Road in Cumming, Georgia. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court appearances, meeting with lawyers, and medical appointments or medical emergencies. Stay out of Fulton County unless you're here for court or to see your lawyers. That means you stay up there in Cumming, Georgia. You do not come to Fulton County, sir, unless you're here for court or to see your lawyer. No further contact with Trooper Jordan Buffington. No further contact with Evan Johnson. And no further contact with Sergeant Salvador, Salvador Ortega, Ortega. And that ankle monitor will be paid for by the county, that 24-hour curfew. So I will do 3,000, 6,000, 1,500, 1,500, 3,000, 500, 500, 500, 6,000, 500, 6,000, and 6,000. You got that, Miss Williams?
No, Your Honor. Can you repeat that one, please?
3,000, 6,000, 1,500, 1,500, 3,000, 500, 500, 500, 6,000, 500, 6,000, 6,000. One more time?
How many charges do you have? Because I'm
I
not
have
coming up with
1,
that same thing.
2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
See, I have
Previously,
13.
I got theft by receiving, ag assault, 2 criminal damage to property, willful obstruction, no insurance, attempt to misrepresent tag, failure to yield right of way, reckless driving, failure to obey traffic signal, hit and run, and fleeing and attempting to elude.
Okay, and it was 3,000, 6,000, 1,500, 1,500, 3,000, 500, 500. What was that one?
500
as
on
well.
failure to yield. Then
6,000 on the
6,000.
reckless.
Uh-huh. Then
And then
500,
5.
6,000, and 6,000.
Okay, got it.
All right,
Thank
and you
you.
got all the conditions?
Yes, I have that.
All right, stay out of Fulton County, sir. Best of luck to you. You can leave the booth. Do we have William Pryor? So is Miss Sampson here? Oh, so that was an ex parte pending. Did that one get handled, Mr. Cazzoli?
Your Honor, Attorney Sampson forwarded messages between you. I know you see a lot of clients, but I believe I'm basing this off what you and Miss Sampson said. That sorry, give me just one moment. I can pull it up.
Did it? Because it probably did. Yeah, I did get a lot of emails today. Let's see. I think maybe it did.
I believe they came off it, Your Honor. Here, I will look for it though.
Hold on 1 second. Oh, wait, here it is. It said, hold on.
Oh yes, Your Honor. Mr. Pryor was found competent, so we want to put him on bond.
All right. So this is William Pryor, 22 CP 211016, 225 days without indictment. There's a $17,500 good bond for criminal damage to property, second degree, terroristic threats. Pre-trial.
Just a second. Prior. William Pryor, 3 prior arrests. Conviction of criminal trespass, family violence in 2022. Nothing further.
All right, Mr. Cazzoli.
Thank you, Your Honor. Mr. Pryor is 25 years old. He has had a birthday in the jail since his arrest, which I believe, Your Honor, his first appearance for this was in late July. So we're over 6 months. He was born and raised in Georgia. Your Honor, he had been working painting houses. He was engaged at the time of his arrest, and had a stepson on the way. I can't speak to the birth of that stepson. Your Honor, his bond is currently set at $17,500. This is the first time his bond has been addressed, Your Honor. So we're asking for a more significant decrease than you might see if this was an every 90 days situation. His bond is currently set at $17,500. We're asking for that to be reduced to $5,000. His charges are criminal damage to property and terroristic threats. Your Honor, these are not there was no violent act here, so we're just asking for a $5,000 bond.
And where will he be living?
Your Honor, I'm sorry, Your Honor, one moment here. I believe we have the address that I currently have is 2121 Hollywood Road Northwest. I would have to double check with Attorney Sampson, but Attorney Sampson knows that if there is a change of address, she will certainly file it.
Is that where you're going to be living, sir? Thumbs up or thumbs down? Thumbs down. Are you going to be living in Fulton County? Thumbs up or thumbs down? Will you be living in Fulton County? Thumbs up or thumbs down? Okie doke. Let's see. It looks like on that state case too, I see it was unsuccessful termination of probation. And the other failed to complete the following: DV counseling and mental health, and didn't pay restitution. All right, what says the state?
Judge, the state spoke to the victim in this case today, actually this afternoon. This afternoon, the victim stated that, and that's Miss Caroline, the victim Caroline Letty. The state also contacted, although I did not personally make that contact, Mary Wicks, another one of the victims.
Judge, there is someone on Zoom with that name. The victim is on Zoom.
Mary Wicks, are you here?
The Caroline.
Caroline?
Letty.
Caroline Ledley?
Ledley.
Ledley,
Yes.
Caroline Ledley?
My
Yes,
Midwest is
present.
coming out there, Judge.
So Miss Caroline, if you want to speak or say anything, you have to you take your camera off for me. Turn your camera on.
Okay, 1 second.
Judge, Miss Ledley reported to our victim witness person, Miss Rivera Gao, that she has called 911 on this defendant approximately 90 times. That he has been terrorizing the neighborhood for a long period of time. Judge, the bond that's been set, I understand that this is that he is entitled to the bond. In fact, does have a bond. Certainly more than reasonable, given this ongoing course of conduct and his ongoing terrorizing the neighborhood, and particularly Miss Ledley and Miss Wicks. Judge, the state does object to any change in his bond status, would request that the bond status include a strict stay away, not only from Miss Ledley, but also from her address, as well as Miss Wicks and her address. Also, a very strict no contact with either of these two victims. Would request a 24-hour house arrest, with the only exceptions being a medical emergency where he's actually taken away from his residence in an ambulance, and in court, in-person court appearances. Having said that, it is the state's position that the bond amount is certainly, as I said, more than generous. Would ask for these additional restrictions to be placed on this defendant.
All right.
Your Honor, if I may respond.
Sure. Let me hear from these alleged victims first, really quick, Mr. Cazzoli.
Yes, Your
Let's see. Where's Miss Ledley? And Miss Wicks, if you'll both raise your right hands. Your military right, there you go. Do you swear or affirm testimony you're going to give is a truth, whole truth, nothing but the truth? Miss Ledley, could you just say yes?
Yes.
And Miss Wicks, can you say yes?
Yes.
Okay, Miss Ledley, y'all can put your hands down. Miss Ledley, anything directly related to bond? I mean, I've read the warrant, so I know the facts of the case as they're stated in the bonds. Is there anything you would like to say?
Yes, Your Honor. I would say, I think with Mr. Pizzoli, some of the things that he said that that William may have shared with his background actually don't seem to be true in regards to job and some of the other stuff. And I will say that 90 911 calls were actually not me. It was throughout the entire neighborhood. There was just kind of significant terrorizing of the entire neighborhood, with a kind of emphasis on women and children. And really, I don't think there's any residence this individual could possibly go to. I would also say that the address listed for me would not be accurate anymore, because I had to sell my house and move. We, for a 2-year period, had multiple agencies involved, everything social service wise up to Homeland Security. So I just really want to emphasize, we are just excited to have this opportunity to talk to you, because we're really hoping that this cycle just doesn't continue. I think you said earlier, seeing how domestic violence can turn into something else we're kind of confident that's kind of what we're looking at here too.
5 North, booth 1, sit up straight. 5 North, booth 1, sit up straight. Head up, sit up. There you go, sit up. We're all awake, so sit up. So Ms. Wicks, go ahead. I'll hear from you.
Yes, I in agreement with what Miss Ledley has said. I have been an advocate for William for years and years and years in this neighborhood, and his violence was escalating. There was violence that did occur, and the incident that happened in July with the destruction of Caroline's current residence's front door, along with some furniture on my front porch, was thrown around. He also took a metal lock to my car.
Your Honor, objection. This is not an evidentiary hearing.
Yeah,
I'm trying to state that I do believe William, someone who has given care and attention to William, and Caroline mentioned that domestic violence can escalate. I've given care and attention to William through the years, and he escalated on my property, on my personal items. And I do fear that he doesn't know the difference any longer. And I fear for our safety and the safety of the neighborhood.
Okay, and it does look like at 2579, this was apartments, but that's the other conviction was someone at or about that same address of the previous one where he wasn't successful in completing his probation. But go ahead, Mr. Cazzoli.
I'm sorry, Judge.
Thank you, Your Honor. I have no questions for the witnesses if you'd like to dismiss them before my argument.
Okay, thank you, Ms. Wicks. Thank you, Ms. Ledley. You can feel free to leave. You can continue watching on YouTube. You can stay on here. Either one that you want to do. Obviously, you have the right to stay in here and listen if you like. Go ahead, Mr. Cazzoli.
Thank you, Your Honor. More a point to Mr. White's argument, Your Honor. We understand that the 17,500 may have been a fair bond. It may have even been a generous bond 200 days ago. We've now reached a point where we're several months away from that. There has been no movement. There has been no preliminary hearing. He's still being held on the accusations that are contained within the warrant. As you know, and we know that the state knows, that if it has the grave concerns it has about the safety of the community, Your Honor, that this case could always be indicted to move that along. Furthermore, Your Honor, I think it's no secret that Mr. Pryor has had some severe MH issues, kind of culminating in that exchange between you and Ms. Sampson that deemed him competent. Your Honor, but a major change, a true change in circumstances since his arrest is that he is successfully being treated now. He is on meds now, Your Honor. So it's our position that, this would be, one, Your Honor, that would be a reason that we would ask again for standard exceptions to a curfew, not just, we would like him to be able to seek preventative care, not just be carried off in an ambulance. So we are asking for that bond to be reduced for those reasons, Your Honor.
All right, so that Ms. Ledley
Judge,
okay, go ahead.
I apologize.
No, go ahead.
Not to prolong this. The state would note that the address 25844 Forest Avenue is less than a half mile from 2127 Hollywood Road, which is the incident location.
Right, sir, do you have anywhere else that you can live besides Hollywood Road? Thumbs up or thumbs down? All right. So, Ms. Ledley, Ms. Wicks, I'm going to modify these bond conditions a little bit. So, since I'm modifying it, I'm going to reduce it just a wee bit because I'm adding some things. The other judge did not have a lot of stuff that I'm going to add. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, and medical. Court, lawyer, and medical. That means you go straight to court, you go straight home. You do not go by 2579 Forest Avenue, and you stay 200 yards away from Caroline Ledling, Ledline, and Mary Wicks, Wicks. That ankle monitor will be paid for by the county, sir. Also, you comply with any treatment that it's going to be Miss Sampson gets you into. You have to comply with any treatment that they get you into, and you have to start that I don't know if they're going to revoke you on the state court because you didn't complete in your probation. You need to get into an anger management class. And sir, you need to learn what this means. Don't bite the hand that feeds you. You had two people reaching out to help you, and you allegedly did what they did. That what it says you did is you threatened to burn their damn house down. And that's not a good way to repay people that are trying to help you. So I'm going to go $2,400 from $2,500 down to $2,400 on count one and $15,000 on count two. Ma'am, both of you, I added the ankle monitor, the curfew, and the no drugs, no alcohol, no weapons, and the stay away. Best of luck to you, sir. You can leave the booth. Thank you, Ms. Wicks. Thank you, Ms. Ledlin. Let's see. Do we have Anthony Jones? All right, Ms. Collins, it's number 7, Bostic 22 CP 214179. Anthony Jones, 108 days without indictment, no bond on possession of fire by a convicted felon. During the commission of a crime.
Your
Honor,
actually, he's represented by a private attorney, and she's on Zoom. I sent you the information earlier.
Okay.
I am.
Sorry, Ms. Robinson, I probably wouldn't use it because let's make sure I updated the amount of time in custody. Where's?
She's under the name
I'm
Caroline.
sorry. Can you hear me, Your Honor?
I can, Ms. Lynn, but I can't see you.
Okay, yes, Judge. I was just saying that I just put my vehicle in motion right before you called his case. But if you give me a moment, literally 10 seconds, I can get my vehicle stationary and I am ready to proceed.
If you find somewhere safe, I'll just go to the next one. It's not, my public defenders usually go pretty quickly. All right, Isaac Brunson.
Well, I'm safe. I'm safe right now. I'm stationary. I'm ready to go.
All right, got to turn your camera on.
Yes, Judge. Okay,
Right.
can you see me, Your Honor?
Possession of firearm by a convicted felon, 108 days, no bond, free trial.
Which person?
This is Anthony Jones, number 7.
Anthony Jones, Judge, on probation 17 SC 153797, burglary, MDMA, sentence 12218, 5 years confinement, 10 years probation, sentence on the same day, 15 SC 132108, robbery, firearm during, firearm by. Prior convictions, MDMA, misdemeanor possession, obstruction. Appears to have another open case, 22 CP 213992, theft by receiver, stolen property, cocaine, and firearm by a convicted felon. Nothing further.
All right, go ahead, Ms. Lynn.
Thank you, Judge. As you may recall from when we were in court back on the 27th, Mr. Jones is 39 years old, Your Honor. He's a native of Atlanta, Georgia. He's resided in Fulton County predominantly his entire life. He's a father of 3. He has 2 daughters, ages 17 and 19, and 1 son, deceased, age 14. Judge, despite not having much education, he did not go beyond the 3rd grade. And he had some challenging circumstances clearly throughout his childhood. He has impressively had an employment background for the past 25 years off and on in brick masonry and also in commercial and residential real estate. Judge, the facts of this case, and I'm sure you have the warrants there, allege that Mr. Jones committed the offense of possession of a firearm by a convicted felon. I just want to highlight the fact that Mr. Jones was located in a vehicle as a passenger that he did not own and that he was not operating. And in addition to that, there has been an affidavit presented to the state probably over 2 months ago at this point, where a individual named Priscilla Williams is attesting to the fact that the firearm does belong to her and that she had placed that firearm in that vehicle. And so, Judge, we are asking that a reasonable bond be set in this case. Mr. Jones has been in custody approximately 105 days with no bond since on or around November 22nd of 2022. You may recall me expressing that he also has medical issues. He's dealing with kidney issues. He has been treated in the infirmary inside of the Fulton County Jail. However, they have expressed that they are not equipped to deal with the extent of his issues, and he does have medical appointments set at Grady Memorial Hospital that he would only be able to keep up with and attend upon being released. And so we ask that you do set reasonable bond in this case, considering that he's been in custody for over 3 months with no preliminary hearing either. He will reside here in Fulton County at address 222 Tuskegee Street, apartment 604 in Atlanta 30315.
All right, go ahead, Mr. Wright.
Judge, the state will note that now 2 separate women have taken responsibility for the firearm that this defendant used in another forcible felony. This is a 133, not just simply a felon in possession case, Judge. At this time, understanding that this defendant is entitled to a bond, given his significant history, and given the fact that that this is a mandatory time and confinement case, there's always a significant danger of this defendant failing to appear, failing to comply, especially because he's got another open case. He's currently on probation. Judge, the state would request a bond that includes no less than 6 figures, and would request an ankle monitor, 24-hour house arrest, only exceptions being medical emergencies when taken away from his residence, in an ambulance, and in court, in-person court appearances. Nothing further. Also,
Judge,
I'm sorry, Judge.
oh no, go
Also,
ahead.
that this defendant stay away from both of the women who have taken and have no contact with, both of the women who have attempted to take credit for having the defendant's firearm.
I have a McKinney Dunbar. What other name do you have?
I'm trying to find the other name, Judge.
I think it's in the other.
I don't have a note from January the 16th. 2 separate women have
That
taken
Destiny.
Destiny, whatever her last name is.
And Judge, if I may.
Go ahead.
Judge, I would just vehemently object to a bond being set in the amount of 6 figures in a case such as this. There's one offense that Mr. Jones is being charged with. That would be, in my opinion, certainly highly unfair and excessive bail. In terms of 2 people taking responsibility for items that they are attesting in notarized certified affidavits that belong to them, Judge. In the first case, the items were the firearm in particular, and other items were allegedly found in the bag of the co-defendant, who acknowledged at the time that it was her bag, and there were items inside of the bag that tied her identity to that bag. And Mr. Jones was not in any actual possession of that bag whatsoever. Ms. Taylor was logged on the last hearing. She's logged on today and can attest to that if Your Honor wants to hear that. In the other case, Judge, again, the vehicle was not one that was owned or operated by Mr. Jones. He simply was riding in the vehicle when the stop was made. The co-defendants actually, either his first name or his surname is Dunbar. I heard Your Honor refer to that person. That's not one of the females. That is the co-defendant, of which there was controlled substances allegedly found on his person, of which he was completely and fully charged with. In this case, he currently has additional charges now on a more recent case where he was just taken into custody for similar offenses. And so I think that goes to show that there's a likelihood that my client was simply in the wrong car at the wrong place at the wrong time. In terms of probation, Judge, I'm not under any knowledge that he has an active probation. There is a probation pending that may come down the pipe, but I don't believe that he's on any active probation to my knowledge. And so in terms of a flight risk and certain things that the prosecutor alluded to, as I said, Judge, she's a 39-year native of this county. he has counsel. He has been very interactive with me, keeping up with his case, calling when he can to discuss this matter, Judge. I don't feel like there's any reason to believe that he would take flight or that he should be restricted from interacting. Maybe with his co-defendant, Ms. Taylor, I could understand that, Judge, but the other person that owns the firearm, I don't think there's any reason to restrict him from interacting with that person. There's no proof that he's tried to intimidate witnesses or circumvent the judicial process. And so I ask that, again, you set reasonable bond. There's one offense on this case, one charge, possession of a firearm by a convicted felon where he was not in actual possession. His firearm was not on his person and in a vehicle that he does not have any ownership or operation over. So we ask that the bond be set reasonable, Judge, akin to what the amount was in the prior hearing that we had on the 27th, which I don't believe exceeded $2,000. He's been in custody over 90 days, no indictment, no prelim, Judge. He's entitled to a reasonable bond.
So I was looking through this. So, Right, no drugs unless prescribed, no alcohol, no weapons, no further contact with McKinney, M-A-K-I-N-I, I think it's Dunbar, D-U-N-B-A-R, no further contact with Destiny Taylor.
Judge, and can we have that be no violent or harassing contact? I mean, I know this is in a domestic case, but.
No, because the condition of his other one says no contact, period. So I'm not gonna contradict the other one because it says no contact on that one. Mr. Jones, I'll tell you one thing. Your lawyer's going to tell you this, consider this, whatever you want to consider it. I have relatives I won't get in their car, and I won't let them in my car, and I won't go to their house, and I ain't going to let them come to my house, and there's reasons. And I don't know if Mr. White wants to admit it or Ms. Lynn, but I know most of us have them relatives. You ain't getting in my car, and you ain't coming to my house. And there's reasons. And if I was a felon, I wouldn't get in the car if they had a gun or be in their house. And no, I know those relatives that they know. I hope they're watching. And I'll tell them right now this is why they ain't allowed in my house or in my car. And no, I ain't driving their car. So you got to be smarter than everybody else because you're the one in trouble, Mr. Jones. You are the one that's in trouble. Because if they've got it, you in trouble. Am I right, Miss Lynn?
Absolutely. I have those relatives.
Miss Lynn won't admit her relatives, but we can talk later.
No shame in my game.
Yeah, I mean, they are. Seriously. I mean, I have relatives that are in prison, and they ain't coming to my house. They ain't bringing no bag, ain't dropping off nothing. No, I'd pat them down before they come to my house. Let's be honest. All right?
Very true, Your Honor.
So, you got this other one. I don't know what they're going to do, but you got an ankle monitor with a 24-hour curfew, court, lawyer, medical, and employment. If you work, sir, brick mason or whatever you got to do, you got to supply the name of your employer, proof of employment, a schedule, and the location you're going to be working. Got to supply that to Miss Lynn and the ankle monitoring company. $10,000 good bond. Best of luck to you, sir. Choose your rides wisely. Thank you.
Thank you, Judge. My big excuse.
Yes, ma'am. All right, Isaac Brunson. Isaac Brunson. No Isaac Brunson. Kenneth Robinson. Kenneth Robinson, that's you? All right, Kenneth Robinson, Miss Correa. 22CP208384. Kenneth Robinson, 341 days without indictment. There is a $150,000 good bond as of 6/23 for battery, family violence, and 2 counts of cruelty to children. Let's see. We reset this because you were in court on another case at the time of the bond hearing. Free trial.
Ms. Bostic, if you're speaking, you might be on mute.
Bostic. I knew it was too good to be true, Miss Correa. She was being good. Oh, Johnny on the spot. Where'd she go? Did we kick her off?
I don't know where she
She's
went.
not on the Zoom call.
Come on, Bostic. Let me. You know she don't pay her internet bill. Hold on.
Judge, I've just admitted her back in.
Oh, did you? Okay.
I can be Bostic right now, Your Honor, if you let me.
You can be Bostic. Bostic.
I'll agree to Miss Gowdy being Miss Bostic.
You all can take my place.
All right, Bostic. Bostic
What number?
1.0, the original. We on Kenneth Robinson.
Moment.
Everybody wants to be you, Bostic.
No, they don't. Robinson, extensive history, 39 prior arrests, first offender, burglary, and 05 terroristic threats, 06 theft by receiving first offender, FTAs 2, 3 arrests for probation violations, prior cruelty in the third and battery, and aggravated assault. Currently has an open case 23 SC 185889, aggravated stalking. Nothing further.
All right, go ahead, Miss Correa.
Thank you, Your Honor. As you've already noted, Mr. Robinson has been in custody for we're less than 30 days out from 1 complete year. Part of that was due to this indicted aggravated matter that Madam pretrial just read out. However, in the 1 year that Mr. Robinson has been in custody, the state has managed to indict that aggravated charge and then even re-indict it. But however, this unindicted case remains lingering. It could have been included in either one of the 2 prior indictments. For the other cases, he was arrested at the same time for these offenses. Since his arrest nearly a year ago, Mr. Robinson has already had a preliminary hearing on the matter before you today. That preliminary hearing happened on September 14th of 2022. So we are significantly removed from that. This is his first court date on this unindicted matter since then. So it's been about 5 or 6 months, Your Honor, that he has been held in custody on this bond with no movement from the state. Since his incarceration, Mr. Robinson's mother has started intensive dialysis treatment for her kidney failure. I'm happy to provide a letter from her medical doctors from that. I was able to obtain that from Mr. Robinson's family. I have been in contact with his sister and his father. I believe that his family was in court with him earlier today on the indicted matter. I spoke to his father this morning about that. Furthermore, the address that you see reflected that has since been updated since Mr. Robinson's arrest. He would not be residing at the incident location. The address that you see reflected is his sister's address that is out in McDonough. That is where his mother also resides there, so that way he would be able to help take care of her. At this time, I'm asking Your Honor to provide a substantial reduction given the lack of movement on this unindicted matter. I'm asking Your Honor to consider setting a $15,000 bond rather than a $150,000 bond. Thank you, Judge.
All right. Mr. White.
Judge, the state will note that one of our victim witness advocates had contact with the victim in this case today. She reported that the defendant has had contact with her both by sending her text messages and also a letter. He has been held on the indicted case. Also on this case, Judge, we would note that he is still a significant danger to the victim, that he has disregarded the court's orders, especially regarding this victim. $150,000 bond seems certainly appropriate in this case, especially given the allegations and the fact that he has failed to comply and has continued to attempt to contact this victim. The state does oppose any change in the bond in this case. If the court is inclined to change, the state would request a 24-hour curfew enforced by an ankle monitor, no exceptions, except medical emergencies when taken out of his sister's residence in an ambulance, and in court or in-person court appearances.
All right.
Strict no
drug-
contact with the victim.
All right, no drugs. Okay. First of all, Mr. Robinson and Miss Williams, put this on. Today, just like I said last time, today, you are not to reach out to any of these alleged victims in any way, shape, or form. That is a violation of your bond. That will lead to aggravated stalking. That will lead to another charge. I don't know if you didn't believe me before, but you better believe me now. No drugs unless prescribed, no alcohol, no weapons, no further contact with Amber Cooper. No further contact with Aaliyah, A-A-L-I-Y-A-H Smith. No further contact. I'll spell this name, A-Y-D-E-T-H-I-O-U-S, last name Graham. You can still have that ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical only. And you also go stay out of Fulton County unless you're for court or to see your lawyer. No other reason for you to come to Fulton County. Don't get gas, don't get a flat tire, don't get lunch, don't stop for anything. If your mama lives somewhere else or somebody else lives in Fulton County, they need to come see you. You cannot go see them. Stay away from 620 AMAI Drive Southwest. I think I said no drugs, no alcohol, no weapons. 50, 49, and 49. And that's because I made a couple of changes. Best of luck to you. 50,000, 49,000, 49,000. Best of luck to you, sir. When you come back, we'll see if you've listened to my orders. I'll also include this in an email to Miss Willis as soon as I finish up today. Thank you, sir. You can leave the booth. Marquay Sims. Marquay Sims, there you go. All right, Miss Gowdy. 21 CP 204762. We still got Bostic. 471 days without indictment, aggravated assault, possession of a firearm during the commission of a felony, and simple battery. Free trial.
Marquay Sims, that is, has a hold in Douglasville, PTI on robbery, open case 22 SC 184-731, aggravated assault, aggravated strangulation, firearm during battery, simple battery, assigned to Judge McBurney. Nothing further.
Ms. Gowdy, there's already a $23,000 good bond. Go ahead, Ms. Gowdy.
It is, Your Honor. Thank you, Judge. Before the course, Mr. Sims, he's 24 years old. He does have a good address. I did file a change of address in this case, Your Honor. It is the address reflected on that document. That's 3001 Bay Rose Circle, Atlanta, Georgia, 30344. He does have good employment waiting for him at the Steak and Shake, where his mom is a manager for Lisa in this case, Your Honor. I will note for this court that this case already had a preliminary hearing last year, Your Honor. It's been approximately 6 months since that prelim, maybe even more, Your Honor. The other case in front of Judge McBurney is an accompanying case, Your Honor, same victim, similar circumstances, Your Honor. But in any event, Judge, that case is indicted back in October of this past year, Your Honor. That case is headed towards a case management calendar, to my understanding, and then pretty soon a final plea calendar, Your Honor. That case has been waiting for this case to be also indicted so that Judge McBurney can handle both cases alongside each other, Your Honor. Bond in this case is $23,000. Your Honor, placed this back on a calendar to check on the status of indictment, Your Honor. The bond is currently $23,000. We're asking for a $10,000 bond, $5,000 on the aggravated assault, $5,000 on the firearm. Use your through the jail on the battery offense, Your Honor, with the same conditions to remain in place, Judge. Thank you.
Mr. White.
Judge, as Ms. Gowdy pointed out, it's the same victim. This defendant is a significant danger to this victim. Should he be released from confinement? Judge, $23,000 is certainly more than generous in this case, especially because this is the second case involving this same victim. The state does object to any change in the bond in this case. Nothing further.
The add-ons, no drugs unless prescribed, no alcohol, no weapons. Where is this one? 1 second. No further contact with G-E-N-I-A-R-A Shonquil, S-H-O-N-Q-U-I-L, last name Ford, F-O-R-D. stay away from 2500 Center Street in Atlanta, Georgia. Could have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Let's see. 1 second. Where's this other man? Does he have a job, Miss Gowdy?
Yes, Your Honor. His mom works for a Steak and Shake as a manager, so he'd have employment there.
I remember that. She's going to get him a job. All right, you can go for employment as long as you provide proof of employment, name of your employer, schedule, and the exact location you'll be working. So if you get your schedule weekly, sir, you're going to have to supply that to the ankle monitoring company and Miss Gowdy so that she can make sure that she supplies that to the state. $15,000, $5,000, and $1,000. $15,000, $5,000, and $1,000. I'll also include this on the email, Ms. Gowdy. Best of luck to you, sir. You can leave the booth. Carlos Davis. All right, it's 22 CP 214294. Carlos Davis. No bond as of 11/29, 102 days without indictment, theft by shoplifting, felony. 2 counts of aggravated assault, possession of a firearm by a convicted felon, and possession of a firearm or a knife during the commission of or attempt to commit certain felonies. Pre-trial.
In regards to Mr. Davis, 31 prior arrests, currently on probation, 19 SC 167345, theft by receiver stolen property, sentence 10, 10, 19, 1 year confinement, 4 years probation, 8 other felony convictions, and 5 arrests for probation violation and parole violations. Nothing further.
All right, go ahead, Mr. Houston.
Yes, Your Honor. Before you is Mr. Davis. He's 43 years of age. He does have a fiance with 5 stepchildren. The oldest being 15, the youngest being 6. Born and raised here in Georgia, specifically in DeKalb County. If given a bond that he can make, he will live at 1993 Bent Creek, apartment K, as in King, 103, Atlanta, Georgia. He would live at that address with his sister. His does have community ties, strong community ties. Born and raised here in DeKalb County. All of his immediate and distant family are here in Georgia. Does have his GED. Does have his forklift certificate. Prior to his incarceration, he was working in landscaping and also working in the fashion industry as an entrepreneur. I understand that he has many cycles, Your Honor. He's been incarcerated for over 100 days without indictment or a preliminary hearing. For the theft by shoplifting, we would ask for a bond of $2,500 for each of the act assaults. We would note to the court that the alleged weapon was not pointed at anyone and no one was harmed. But we do understand the seriousness of the charges. We would ask for $10,000 on each ag assault. For the possession of a firearm by a convicted felon, we would ask for $5,000, and for the possession of a firearm during the commission of or attempt to commit a felony, certain felonies, we would ask for $5,000. That is all. Thank you, Your Honor.
All right, go ahead, Mr. White.
Judge, the state would note that Mr. Davis has managed to chalk up about 1 arrest every 9 months and 1 conviction about every 30 months since he reached the age of 18. 1 felony conviction about every 30 months since he reached the age of 18, and that includes the time that he has been incarcerated pending this case. The state does recognize that he is entitled by law to a bond. He's currently in a no bond status. The state would request that any bond include strict 24-hour house arrest, only exceptions being medical emergencies when taken away from his house in an ambulance, and in-person court appearances. Would ask for a strict stay away from, I had the name of the establishment.
Home
And
Depot.
lost it.
Home Depot.
Home Depot. Would stay away from all Home Depot stores in the state of Georgia. No exceptions. During the pendency of this case, nothing further.
No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendant. Iyanna, last name Cleveland, common spelling. No further contact with Vernon Bush, Bush, no further contact with Robert Fleetwood. 5 North. I don't know what's going on behind you, but it ain't as important as what I'm saying. Stay away from 2525 Piedmont Road. Stay away from all Home Depot stores, all of them, no matter where it's at. And he's not going to live in Fulton County. He's not going to live in DeKalb County anymore. He's going to live in Fulton. Sorry, you're going to live in Fulton County? All right. You're going to have ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, and medical. 5,000, 15,000, 15,000, 10,000, and 10,000. 5,000, 15, 15, 10, and 10. Ankle monitor will be paid for by the county. You have 48 hours to have that ankle monitor placed on you in case there's a hole. Best of luck to you, sir. You can leave the booth. All right, we have Deshaun Lay. All right, let's see. We got 2 cases, Mr. Lay, at 22 CP 213839. Theft by receiving stolen property. There's a $25,000 good bond as of November the 10th on theft by receiving stolen property. Then you got 22 CP 213840. There's no bond on home invasion in the first degree, aggravated assault, possession of a firearm or a knife during the commission of or attempt to commit certain felonies, terroristic threats, felony, false imprisonment, aggravated assault, strangulation, battery, and call otherwise contacts 911 and fails to hang up, disengage, connect for the purpose of interfering. Free trial.
Judge, in regards to Mr. Lay, 1 arrest in Alabama was for a violent offense, 3 in Georgia. Doesn't appear to have any convictions. Open case though, 23 CP 215235, 2 counts, capital offense. Nothing further.
And I think, Mr. Cazzoli, it looks like I have a Smyrna address.
Yes, Your Honor. I have 601 Cobb Crossing Southeast, Smyrna, Georgia, 30080.
All right, go ahead.
Your Honor, he is 22 years old. He lives at the aforementioned address with his grandmother and grandfather. He's been living there for the last 3 years. He is a lifelong Atlanta resident. His entire family on his dad's side is from Atlanta as well. He has 1 kid on the way, a son who is due in June. He's a high school graduate. Your Honor, he was painting houses before his arrest. He can go back to that, but he was also planning to interview for warehouse jobs. So that would be his preferred work. Your Honor, as mentioned, he does have a serious open case, but that I believe he's being held on no bond for. And his remaining 2 cases are with me. On position 4, which is a single theft by receiving, we're asking for a bond not to exceed $5,000. On position 5, we're asking for a bond not to exceed $60,000. $10,000 on the first charge on the calendar, $10,000 on the second charge, $5,000 on the firearm, $5,000 on terroristic threats, $10,000 on the false imprisonment, $10,000 on the aggravated assault, $5,000 on the battery, and $5,000 on the disruption of a phone call.
All right, what says the state?
There's
I think he's already on no bond on his 2 counts of murder.
no bond. I'm just trying to see the date. I saw the offense date. Okay,
And there's a bond order there by Judge Bart, but there's nothing on there. She put
yeah,
no bond.
I'm trying to make sense of that one, Judge.
Yeah.
The bond order is from January the 7th of 2023. I'm just trying to figure out if that was the first appearance or not.
ADA White, this offense is from his arrest was in November of 22.
And it looks like the bond order from March of 2023, it was Judge Barwick. So that wouldn't have been first appearance. That probably would have been when she was presiding 1 week.
Yeah, that would have been a presiding.
And it doesn't have anything on it. So it looks like she's stuck with no bond.
I'm just trying to make sense of that because if his arrest date was November, then that's more than I don't know why this isn't indicted, Judge.
I don't know. The offense date on this was, second day of November 2022.
I mean, we've got basically 2 capital offenses. We've got a home invasion and then a much more serious capital offense. neither of which the state has managed to do anything with.
You're taking the words right out of Mr. Cazzoli's mouth.
Yeah. The state would request a 24-hour house arrest with the standard conditions and such bond as this court deems appropriate. That's really all I can say.
All right, sir. So you're not getting out. Mr. Lay, you got 2 counts of murder. You got no bond on those 2 counts of murder. So on the case ending in 3839, theft by receiving stolen property, no drugs unless prescribed, no alcohol, no weapons, no further contact with TYAJA, last name Callaway. Stay away from 785 Lee Street. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, period. Stay out of Fulton County unless you're here for court or to see your lawyer. $50,000 good bond on that one. Yeah, then you got position 5. No drugs unless prescribed, no alcohol, no weapons. Stay away from 800 West Marietta Street, number 908 in Atlanta, Georgia. No further contact with Haley, Haylee Blanton. No further contact with Christina Huntington. Sorry, I can't even read my handwriting. Huntington. No further contact with Alex, Meneses. You're gonna have ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, that's it. You're gonna stay out of Fulton County unless you're here for court or to see your lawyer. 100,000 home invasion, 100,000 ag assault, 50,000 possession of firearm during the commission of certain felonies, 50,000 on terroristic threats, 50,000 on false imprisonment, 100,000 on the ag assault strangulation, 50,000 on battery, and 5,000 on 911 call. 100,000, 100,000, 50,000, 50,000, 50,000, 100,000, 50,000, 5,000. Best of luck to you, sir. And like I said, you're still not going to get out even if you make those. Best of luck to you. You can leave the booth.
Your Honor, that concludes my business. May I be excused?
Yes, sir.
Thank you, Judge.
Yes, sir. All right, we got Travis Buford. All right, thank you, Ms. Rosenhuber. This is, and I will also put this one on there, and I'll let you say 579 days as many times as you'd like to. 21 CP 202052, 579 days without indictment. One's got a $240,000 good bond on possession of a firearm or a knife during the commission of or attempt to commit certain felonies, aggravated assault, criminal attempt to commit murder. Then there's another one, 22 CP 210992, unauthorized possession of a weapon by an inmate. There's a $25,000 good bond on that as of February the 2nd. And it's 579 days without indictment. Wow.
There's 25 prior arrests, 1 FTA, 1 arrest for probation violation, conviction 19 SC 171328, hydrocodone and misdemeanor possession, open case 22 SC 181477, armed robbery, aggravated assault with the intent to rob, firearm during, firearm by, signed to Judge McAfee, and a battery, family violence 2015. Nothing further.
All right. Grab Ms. Rosenhuber.
Thank you, Judge. As the court may recall, we were just here on February 2nd, 2023, and Your Honor did specifically request that this case be put back on for a status. At that point, I'll remind the court that ADA had not had any victim contact whatsoever. The state even asked defense counsel where the victims lived. And so, Judge, we are requesting a significant reduction. Mr. Buford is 25 years old. The address on file is a good address for him. He resides there with his children's mother as well as his children. He was born and raised in Atlanta. His mom, sisters, father, grandmother all live here in Georgia. He earned his GED. And most recently, he did have his own business, which he has since lost. Since, Judge, he has been in custody now for 579 days without indictment. If there has been absolutely no movement on this case, these are my requests to the court, starting with 21 CP 202052. We're asking for 5,000 on count 1, 10,000 on count 2, 10,000 on count 3, 15 on count 4, and 15 on count 5 for a total of 55,000. And for the second case, Judge, position number 6 on the add-on, we're requesting a $5,000 bond. Understanding that this is a significant reduction that we're asking for, I also want to remind the court that Mr. Buford does have a valid defense in this case, and he is looking forward to the case being indicted. He was protecting his own home. He does live at the 373 Legacy Drive location where this incident occurred. And so that is our request at this time. Thank you.
All right, go ahead. Mr. White?
Sorry, Judge. I just, looking at the number of prior felonies, and especially the I'm looking forward to the I'm almost almost sad that I'm not going to get to try the or hear the immunity motion on this. Anyway, I'm sorry, I was distracted. Judge, at this time, the state will note that this defendant also has the indicted case 22 SC 18147, what is it, 2, the armed robbery in front of Judge McAfee. Judge, there's been nothing to show that there's been really any kind of a reason to have the bond reduced in this case. The state will object to any change in the bond at this time. Nothing further.
All right, let's see. On the case number 6 ending in 0992. $15,000 good bond, no drugs unless prescribed, no alcohol, no weapons. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical appointments. And where's he going to be living, Miss Rosenhoover?
It is the 373 Legacy Drive Southwest address. And I do want to remind the court that is the incident location. So if we could please not stay away from the incident location.
And that's not where the victim lives?
It's my understanding from the incident report that one of the alleged victims resides at 2595 Graywall Street in East Point, and for the other witness, it's not listed.
Okay. No further contact with co-defendant on this one. Contavious, Contaivias Howard. No further contact with ERON McCary, MCCARY, Larry Thomas, Robert Robinson, or Julian Conley, CONLEY. Like I said, that ankle monitor will be paid for by the county with a 24-hour curfew with that $15,000 good bond. On the case ending in 2052. No further contact with DAWIT, last name Dixon, DIXON, and Sean, SHAWN Davis. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with the 24-hour curfew, except for court, lawyer, medical appointments. Okay, yeah, I did say that before. If they don't live there, we'll take off the stay away from Legacy Drive. Oh, I put only on there, only if the victims didn't reside there. Did they ever reside there? He says they don't. But I'll just tell you this, Mr. Buford, if they live there, you can't go there because you got to stay 200 yards away from them. It's kind of some common sense, okay? No drugs, no alcohol, and the ankle monitor will be paid for by the county. Let's see, you got 6,000, 30,000, 30,000, 50,000, and 50,000. 6,000, 30,000, 30,000, 50, and 50. And like I said, I just added this to my running email to Miss Willis. All I gotta do is hit send at the end of this as I'm placing all of these in my email. Here's where else to go.
Thank you, Judge. And that does conclude my business, if I may be excused.
Okay, sounds good. Let's see. All right, we got Nick Smith. You can leave the booth, sir. Thank you, Nick Smith. All right, Ms. Bray. 20191-831 Nick Smith, 483 days without indictment, robbery by force, aggravated battery. There's a $10,000 good bond as of September the 29th. Pre-trial.
Nick Smith, 14 prior arrests in Georgia, 5 in Tennessee, 1 arrest for probation violation, currently on probation for aggravated assault with deadly weapon, firearm during terroristic threats, 2 counts criminal damage to property, sentence 425-19 for 5 years, 2 convictions for theft by shoplifting.
Nothing further.
Go ahead, Ms. Bray.
Okay, Your Honor, I know you take excellent notes and I know you're sending this email to Madam Willis. I need this case here added to it, not just for the amount of days Your Honor read off. I want Your Honor to take notes on the history. When Mr. Smith was first arrested, it was under booking number 2007269. He was arrested May 13th of 2020. He did not receive a bond. He stayed in Fulton County Jail until September 29th, 2020, when he was then transferred to the Department of Corrections based on a 2016 probation revocation from Judge Ingram. She revoked 18 months. He did every day of 18 months in prison. Then Fulton County kept a detainer hold on him, Your Honor. So the prison, when he was done with his 18 months, they didn't release him. They transferred him back to Fulton County Jail on November 12th of 2021. I've added up the days. The first time he was in from May 13th, 2020 to 9/29/2020 is 140 days. The time he spent, those 18 months, Your Honor, was 409 days. Then they brought him back and he is now at 483 days. But when you add all three of those up, he has been in continual custody for over 1,000 days. It's closer to 1,032, 33, give or take a day. Continual custody. Now, he is 37 years old. He has lived the last 14 years of his life here in the state of Georgia. He did complete the 11th grade. He is the father of 3 children under the age of 10. His prior work experience was with BMS Commercial Restoration, where he had been for 8 years prior to picking up this case. And he was working there doing drywall installation. That is a skill. He should be able to get a job. Your Honor reduced his bond to $10,000 on September 29th, 2022. It was November 2nd of 2022 before he finally had a prelim hearing on this case. I am asking Your Honor to reduce his bond, $2,500 each count, so that I can get him through the bail bond project. He has a stable address. And as long as he has that stable address and he no longer has anything else holding him, then he would be a good candidate for the bail bond project, considering he's been in on this case continually for over 1,000 days and it still hasn't been indicted. And I have emailed list after list to various people there in the DA's office, and his name has been on every single one of those lists.
I wrote it down, Ms. All right, go ahead, Mr. White.
Strains credulity almost to the breaking point to say he's been in for over 1,000 days on this case.
Yes.
Nevertheless, he has been in for about 400 days on this case. I'm just trying to see what address he had.
The 3638 East Clubhouse Circle, Decatur, Georgia.
Well, if that is in fact a stable address, then it'd certainly not be unreasonable to reduce this bond to the $5,000 so the bail bond project can help him get out. However, the state would request a 24-hour house arrest enforced with an ankle monitor with exceptions being medical emergencies and in-person court appearances, nothing further.
I'd like to ask for work because he'll have to get a job, Your Honor.
Okay, Ms. Wiz, if you note over there that Mr. White went to see the wizard, got a heart, got some compassion.
I'm shocked. I can't believe it. That's one of my favorite enemies, Your Honor.
Don't mistake that for a heart, Judge.
All right, 2,500 on each count. No further contact with Johnny Cassius, Cassius. If, like I said, you have 48 hours to have that ankle monitor placed on you. If there's some sort of hold, ankle monitor with a 24-hour curfew, except for court, lawyer, medical, and employment, as long as you supply the name of your employer, place of employment, and the schedule. You have to supply that to the ankle monitoring company and to Miss Bray. And he's going to live in Fulton, right?
Yeah, I believe that's a Decatur address.
All right.
It's a
But now
DeKalb
the
County
work
address.
could be in Fulton,
All
but
right.
I mean, he'd have to, provide proof of that.
All
So
right, so I'll leave it at state of Fulton County except for work, and you must supply a proof of that in a schedule to the ankle monitoring company, but you can't live in Fulton County. So there'll be 2,500 on each. Best of luck to you, sir. I'll send my email. I got Tedrick Witters.
and Your Honor, that concludes my business. May I be excused?
Yes, ma'am, Ms. Bray.
All right.
All right, Mr. Witters, that's 21 CP 200801. I know Miss Bassett's going to say it several times. So 628 days without indictment for aggravated assault. There is a $1,000 good bond on aggravated assault. Pre-trial. Boston, did she not pay her bill again?
Yeah, I did. I was talking, but y'all can't hear me if I'm on mute, I guess.
Okay, Boston.
23 prior arrests, 5 arrests for probation violations, 2 FTAs, couple of drug convictions, currently on probation for cocaine. 21 SC 177876, sentenced in 2021 for 3 years, nothing further.
The floor is yours, Ms. Bassett.
Thank you, Your Honor. If I could say 628 days 100 times in a row, I mean, it still probably wouldn't be enough. We were here about a month ago on February 2nd, and you set this case on this calendar for a status update from the state. I had hoped that there would be an indictment by now or some decision on whether or not to formally charge this case to move forward. I would note also, I have a constitutional speedy motion to dismiss pending. I had hoped that maybe that would get some movement on this case, but so far, no luck. At this point, I don't know what to do for Mr. Witters. He has a $1,000 bond. He's not eligible for an unsecured judicial release because of the charge. He's not able to make any bond. As far as I know, the issue seems to be that the state cannot seem to find their complaining witness unless Mr. White has an update on that. So far, the complaining witness has never appeared at any of the many hearings that we have had for this case, including the preliminary hearing, which was over a year ago. This case was bound over to Superior Court over a year ago, and yet nothing has happened. Mr. Witters is 30 years old. I would note he was 28 when he was first arrested. He is from the Atlanta area. He has completed the 11th grade, and he was about to start a job at a temp service when all of this happened. I would also note that Mr. Witters from day one has asserted that this was self-defense. And he is quite upset. He feels that he has been wrongfully accused. He has not had the opportunity to argue that. I have not had the opportunity to file an immunity motion on his behalf. I have also not had the opportunity to review any discovery because the state has not turned anything over because the case not indicted. I'm not entitled to discovery at this point. 628 days is too long. It's unconscionable. It's inexcusable. And Your Honor, if you read my motion, my constitutional speedy motion, I get quite into my argument there. I will save that for the 20th, which is when that is set for a hearing. For today, Your Honor, I would ask for a decrease in the bond. I don't know that it would effectively make any difference. And just on Mr. Witters' behalf, I would ask the court to consider dismissing this case for want of prosecution.
Yeah, Mr. White. Yeah, Mr. White, I don't I think the only place that used to take a $500 bond is they don't do it anymore, or you basically have to put up $500. I think.
I think it's actually, you have to put up less on $1,000 bond than you do
Right,
on
it's like
a bond under,
$120.
yeah, under 1,000. I think the court is right. As much as I hesitate to agree with Miss Bassett, she does make several compelling arguments. Judge, I really don't know kind of what to say on this one. Other than I imagine the constitutional speedy will be an interesting argument, to say the very least, on the 20th. I don't know where to go with this, Judge. I really don't know where to go with this. I can't explain what's going on. I do have notes in here in Odyssey showing an apparent text message exchange with the victim. From it looks like last month, maybe. But I don't show anything that an indictment's being prepared. I've got nothing, Judge.
See what?
Whatever the court's discretion is certainly I can't make an argument against it.
But let me see if I can't make that phone call to that person.
Excuse me.
He's going to be indicted on Tuesday.
Thank you, Judge.
He's going to be
I'm sorry,
indicted.
what'd you say, Judge?
He said they say he's going to be indicted on Tuesday, but please come. I mean, if you want them to pull him, he can, but please bring him back on Thursday. Wait, next Thursday or
You
next
want me to
Tuesday
add him on next Thursday
or
calendar?
next Tuesday, whichever, to make sure. How about next Thursday to make sure that they've done something?
Okay, so I'll add him to next Thursday's calendar.
Does that sound good? And then you'll have
Thank you, Judge.
And then, of course, once that gets sent out, you'll get the list. And Ms. Bassett, do you get the indictment list?
I do, Your Honor. Thank you so much.
All right. So there you go. Sorry about the phone call, but that kind of called for a phone call. So
I appreciate you, Judge.
Ms. Bassett's gonna get it back. Look, they're gonna try to indict your case on. They're gonna indict your case on Tuesday, Mr. Witters. I'm sure Ms. Bassett's gonna come by and talk to you, explain to you what's going on. Okay. Thank you, sir.
And Your Honor, that would conclude my business with the court this evening. May I please be excused?
Yes, ma'am. Thank you.
Thank you. Have a good weekend.
All right, you too. And I went ahead, Ms. Bray, I guess you may be still here. I went ahead and mentioned the other one. All right, let's see.
Judge, so for the bond on this one, it remains the same?
Yeah, I mean, yeah, you have to remain the same. Yeah, and just put it back on next Thursday. All right, let's see. Marcellus Nelson. Did you get that, Bostic, Marcellus Nelson?
No, the history wouldn't come up.
All right, I think what's Miss Gowdy wanted to play Bostic. Let's see. Marcellus, let's see, 22 CP 210494, Marcellus Nelson, 245 days with aggravated assault with a deadly weapon. And let's see, where'd Miss Gowdy go who wanted to play let me see what I got. I can pull up the pretrial report.
Judge, I have his history.
Okay, go ahead.
He has 4 cycles. Sorry, I wasn't expecting to do this part of it. He
I
has
do
4
know that he does have an
cycles
open case.
and no felony convictions, no violent allegations or convictions. I think pretrial is right. He does have another open case that has been indicted, and they are not able to move on because the state hasn't indicted this case. I'm ready on the bond argument when the court's ready.
All right, go ahead.
Mr. Nelson has been incarcerated 245 days with no indictment. He does have an $8,000 bond. However, he cannot afford that. Since his last bond hearing, Mr. Nelson has been accepted into Georgia Works. We spoke with them when this case was originally on the calendar, February 23rd, and they did confirm that they have a bed available for him. So we are asking for either a UJR to the program or a bond of under $5,000 so we could utilize the bail project. If released, he would reside at Georgia Works, 275 Pryor Street. It's a 6 to 12 month program that provides a variety of services to help men, get stability and achieve what they call independent living. So transitional employment, transitional housing, career development, case management, drug relapse prevention. So there will be, a variety of services available to him. Also, since his last bond hearing, Mr. Nelson has been attacked 4 more times in the jail. Prior to that, he was jumped twice. He lost his 2 front teeth. He's been stabbed. Judge, all we need is to get him out, get him into this program. Regarding the Ayala factors, he does have strong ties to the community. He's 29 years old. He has lived in Georgia almost his entire life. His mother, sister, aunts, cousins are all here in Georgia. He does have a CDL, so he does intend to return to truck driving once he's able to do that. As stated, he's only has 4 cycles. None of them are violent. In this case, where he's alleged to have aggravated assaulted someone, it was self-defense. And if the state would look at the alleged victim's history, he has a very long violent criminal history. Mr. Nelson has no felony convictions. He's not at risk of intimidating any witnesses. He does not know this alleged victim. He has no reason or means of contacting him. Given that Mr. Nelson is indigent and presumed innocent, and he does have this program that we're trying to get him into, as stated, we would ask for either a UJR to the program or a bond under $5,000 total.
All right, what says the state?
Judge, the state would note that on the indicted case, this defendant has a $3,500 bond, which is certainly a very reasonable bond on that case. And actually, that case may play a significant factor in whether or not he is able to get into the program, the Georgia Works program. Also, Judge, given the facts here, $8,000 is a very reasonable bond. I understand that the Fulton County Jail is not the most pleasant of places to be. However, none of what was presented here before the court is really a compelling reason, or even really even a legally cognizable reason to reduce the bond. The state would object to any reduction in this bond at this time. Nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Frederick Kemp, K-E-M-P. Stay away from 780 Morosco Drive North, no drugs, no alcohol, no firearms. He's gonna have to provide an address. He's gonna have to anyway before they'll let him out, right, Ms. Pinto?
Wait, I'm not.
He'll have to
Whether
provide
they'll
an
let him out
address
of
where
jail?
he's living to get out if the bail project's gonna help him anyway, right?
Yes, yes.
Right, you have to provide an address where you're living. Right now, I have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment, as long as you supply proof of employment, name of your employer, and a schedule, the location to Ms. Pinto, and she'll supply that to the state. And if you're gonna be a driver, sir, you'll have to supply proof of anything like that. A $5,000 good bond. Best of luck to you, sir.
Thank you, Judge. And I would just note for the record, for some reason, the calendar states that it was reset from February 23rd to allow me to appear. I was sick. I had someone covering for me that day. It was reset because there was some issue at the jail. So just.
Yeah, and it was allowed you to appear because whatever happened at the jail, I think they said they didn't feel good waiving in their appearance because you weren't there.
Understood.
Yeah, that's what it was. I don't hold it against you.
And may I be excused, Judge?
Yes, sir. Best of luck to you, sir. All right, is Kevin Crawford.
Judge, it's my understanding they're walking him over. Lieutenant just provided me that they're walking him over.
You waved your hand. Are you Kevin Crawford? Okay, he's there. All right, we got 22 CP 213931, 119 days without indictment, criminal damage to property, giving false information to a law enforcement officer. There is a $2,500 split bond with no bond on criminal damage to property. Free trial.
8 arrests in Georgia, 3 in Texas, 1 misdemeanors, 2 FTAs. Open case 21 CP 197778, criminal damage to property. Open case for simple assault obstruction, 21 CR 0078544C. Nothing further.
All right. Go ahead, Ms. Beck.
Yes, Your Honor. Mr. Crawford is 37 years old. He served in the Marines from 2005 through 2007. He is a high school graduate and he's also taken a few college classes. He has lived in Georgia for the last 10 years. He has a good address at 6120 Mozart Drive in Riverdale, Georgia, and that is the address that is on file. We are working to get him into the Veterans Court. The application has been put through. We're just waiting for him to get approved. We are asking for bond not to exceed $5,000. Thank you.
What says the state?
Judge, I do understand that there's a Veterans Court application pending. I actually have it tied to the 21 CP 197778. But it would of course also encompass this current 22 CP 213931. I expected that there would be a decision by now. I'm not sure what the hangup is that there hasn't been one. I believe that when, I guess if maybe he's admitted to Veterans Court, then the Veterans Court will, or at least has in the past, acted as a surety for the bond for the veteran, or at least has found a surety for the veteran. The state at this time would not object to a reduction in bond that would allow this defendant to get into Veterans Court through the bail project or similar.
So are you saying 2,500 on criminal damage or property the second degree? Because that's a no bond.
Yeah, he's definitely entitled to a bond there, and that
And you're fine with $2,500?
I'm fine with that, because I think that would allow him to that would allow us to work with what we need to work with to get him into Veterans Court.
And Ms. Beck, if he gets into Veterans Court, just send me that order.
Okay, I just looked and I submitted the application on January 28th. So I'm not sure how long it normally takes. I can always resubmit it if we think that it may have gotten lost or something. I have no problem doing that. Whatever you guys think is best.
Who is it that approves that? Is that McBurney?
Sistrunk,
Who is it?
Miss Sistrunk and John Collins, and then the state has to sign off on it.
Yeah, maybe send it again and just, you can put in there that I asked to send it again.
Okay, I can absolutely do that, Your Honor.
So we'll do 2,500 on each count. No drugs unless prescribed, no alcohol, no weapons. He's gonna be living in Clayton County? Is that Clayton County in Riverdale, sir? Thumbs up or thumbs down? All right. Stay out of Fulton County unless you're here for court, see your lawyer, or participate in the veterans program. Let's see, stay away from all Taco Bells, stay away from 5119 Old National Highway. No further contact with SYNERA McDowell, MCDOWELL. You have an ankle monitor paid for by the county with that 24-hour curfew. Court your medical participation in the program, and if they want it removed, the ankle monitor removed for the veterans program, then you can remove it for the veterans program. Okay. And sir, please reach out to the VA and get some help. All right. Best of luck to you, sir. $5,000, 2,500 on each.
Thank you, Your Honor. That concludes my business for today. May I be excused?
Yeah, thank you so much.
Thank you.
Okay, let's see what we got left. We got Shaheem Myers.
Excuse me, Judge, this is Lieutenant Conklin. We having some staffing issues at the jail. They are looking for those inmates. They're not in the locations indicated in the computer. However, they are still trying to locate inmate Myers and Brunson, correct.
Can we try 1 North for Brunson? He may be on 1 North.
1 North?
Yeah.
Mr. Crawford, you can go ahead and leave the booth. Yeah, so we got Brunson and Myers is all we're waiting on.
Judge, we do have a add-on that's a walk-on Attorney Corn if we want to take take that.
Yeah, that's a bond modification, right?
Yes, Judge.
That is, sorry about that. Let me pull that one up. Thank you for being patient, counsel, but try to take the ones that are in jail first. That's Jason Haynes.
It is, Judge.
Is Mr. Haynes here?
Yes.
Mr. Haynes, thank you. All right, let's see. Hold on one second. If you could raise your right hand in case you have to say anything, Mr. Haynes, you swear affirm testimony you're about to give. Raise your right hand. Swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth. If you could unmute yourself and say yes.
Yes.
Okay, so right now, he is out on $111,000 good bond for serious injury by vehicle, driving under the influence of alcohol, less safe, too fast for conditions, and driving improper or erratic lane changes. Anything I need to know, Boss Dick?
No.
Usually Boss Dick has so much to say. All right, go ahead, Mr. Corn.
Good afternoon, Judge. Mr. Haynes is 32 years old. He has no criminal convictions or history as far as this case goes. This case, if you remember back to law school, we don't like to think about that quite too often. This case stemmed from a Paul's graph situation. There was the two victims in the case. One of them is a gentleman who's accused in a crime. His name is Mr. Arnold, Charles Arnold, who's sitting currently in the Fulton County Jail. He got into a fight with a police officer, was running from an officer, ended up in the roadway, fighting with the officer on the roadway. Mr. Haynes came upon the two people fighting in the middle of the roadway on a dark road down in South Fulton County, and that's when the accident took place. Mr. Haynes was charged in this case. He bonded out. Currently, Judge, he's been gainfully employed. He's lived in the state since 2017. He works over at the Marriott by Courtyard down in, I would call it Midtown Atlanta, not particularly, I guess that's the best way to say it. He resides in Midtown. He's been spending $300 a month on the monitor that he currently has on his ankle. He's not a flight risk. He's been here for 5 years. He resides, he rents an apartment here. He's checked in daily with the company, cooperated fully with the monitoring company. In addition, this is a case where the police took the black box out of his vehicle, and instead of downloading it, they never replaced it. So he has a vehicle that is unable to be used. He's been spending $700 a month on Uber. We just asked the court to amend the bond to remove the ankle monitor. I'm not quite sure. I didn't argue the bond originally. I'm not sure who did. I don't know why there was an ankle monitor placed on this particular case. We would just ask the court that, you have $111,000 surety in this case that's been posted. I don't know what the monitor provides in this case.
Well, I can tell you that I didn't put it on there. That's just somebody trying to be a copycat. Mr. White knows that because nobody put ankle monitors on anybody till I started doing it. What do you say, Mr. White? Where does he live, Mr. Cohen?
I'll let you.
You said he lives in Midtown, or does he work?
Right, he lives in Midtown, and I can give you the exact address.
You can just tell me the street. I'm familiar with Midtown.
Jason, if you just want to, you can give your street address.
Just give the street, Mr. Hayes. You don't have to give the numbers. Take yourself off mute.
Yeah.
707 Park Avenue.
Okay, you do have to give the numbers. Okay. All right, go ahead, Mr. White. Let's see. I'll give Mr. White a second to look over if he needs to.
Judge, the state would not object to funding the ankle monitor at county expense in order to relieve that financial burden. However, the state really doesn't see, this is only the jail commitment. The arrest was on December the 7th of last year. So what, this case isn't even 90 days old yet. Well, it's just over 120 days old. See no reason to remove the ankle monitor. However, the state does understand that there's a significant financial burden here and would not object to converting the ankle monitor to county expense. Nothing further.
And it looks like an officer was struck with the vehicle, had to have surgery, lacerations on his head, face, arms, and legs. Do we know the?
I'm just trying to see if I've got the current status of the officer. And I don't see any updates on the actual status of the officer in Odyssey, Judge.
I'm assuming the officer was probably like out there and he just allegedly drunk, didn't see the officer and hit the officer.
Well, he was fighting, the officer was fighting with Mr. Charles Arnold, who's sitting in jail right now, 23 CP 215321 in the middle of the road.
Didn't see them.
Right.
All right, if you want to do an order, I'll let it be paid for by the. No, see, I'd gotten when I just spoke with the prosecutor to make sure that other thing got indicted. Won't mention the prosecutor by name. That's who I was calling on the phone. I'd also gotten a text from Mr. White. Do you remember the program I told you about, the company Talatrix? It has the smartwatch.
Yeah, the smartwatch monitoring.
So I got a text from, and let's see, is Miss Phoenix sitting on here? Is she? Or
She's not on here, or Tanika, they're not on here.
Because I got a text from the lady today that says all funding issues have been solved. Orders need to say wrist wearable Talatrix band has to be through A&A, All County Monitoring, which is the company that has the contract. They are now a partner. And because before it said that the judge was going to be the sheriff had somehow backed 500 of these. And I said, well, it's got to be approved through Orca. So do you know anything on the status of that?
I know that it was addressed at last week's Orca meeting, and as of last week, it had not been finalized. I missed this week's meeting because I was in court. So, but as of last week, it had not been finalized.
And it has to be, all right, so I'll change this to county paid. And then like I had just told the public defender, so you can tell all of the private attorneys out there that some of these people have them on for like 3 years or more. And that by no way is what we mean to do, is to keep ankle monitors on people for 3 years. But this did just happen. So we'll change this to county paid if you want to submit the order to me, and I will be glad to sign it and send it back.
Terrific. Will you tell me, Judge, I'm happy to, you want me to email it? Alexandra,
Sure.
where should I send it to?
I can I'll put my email in the chat, so that way, just in case somebody wants to send me a bunch of hate mail when they see this streaming, but they don't get to.
Right.
Let's see here.
So I will email an order sometime tomorrow that just indicates the monitor will be paid for by the state.
Yeah, and tell all the other private attorneys that if they have people that have been on that long, to please, send a motion. They can get on the Orca counter. We can hear it, because people don't need, if there's no violations, people don't need to be wearing these for like 3 years. That's ridiculous. So,
absolutely, absolutely. All right, thank you so much, Judge. We will.
Sure. If you send that order, I'll email it back to you. And then since the Orca staff doesn't file, what do they do, Miss Robinson? They just have to send it in to somebody.
Yes, and if you copy me on that, I can just provide him. It's the clerk of Superior Court jail unit, since it's a CP case. But if you copy me on it, I'll provide him with the email address of where it goes.
Because we've had to mail these for on this particular, anything on a CP calendar, we physically mail them.
You don't have to do it anymore.
You can e-file it. It's just a different e-file address. I can provide that to you.
If you can put that in the chat and send your email address, that would be terrific.
Will.
LCC. Thank you so much, Ms. Robinson.
All right. Thank you, Mr. Hayes. As soon as they get it, as soon as I get the order, I'll sign it. If he sends it tomorrow, I will sign it. I have a full calendar, but I'll make sure I sign it and get it back to Mr. Cohen so he can get it filed with the jail. Okay.
Yeah, Ms. Robinson, just put that in the chat and I'll send it to LCC you on it as well.
Okay, I'm putting it in there now.
All right. Thank you, Mr. Hayes. Y'all stay healthy and safe. Once you finish, you can go ahead and leave. So we're just waiting on those two. Let's see, I think I've completed my. Mr. White, did you want to be copied on that same email?
Yes, please. Thank you.
I mean, not just, you know who I call.
I know who you call.
All right. So, like I said, I know we're all drinking from a fire hose here. I don't.
Your Honor, if I may.
Yes, sir.
We also have another add-on, San Juan Parish. him and Myers were continued today from the last hearing.
Harris
was released already.
Yeah, he was released.
Oh, he was released? Okay, my apologies.
That was a good job, Houston. Got him released already. Yeah, I understand every department's drinking from a fire hose, but I just, and when I say something about night, I'm just trying to be like, hey, this is out there. And then I put Ms. Bray's notes on there. Y'all are gonna miss me when I'm gone.
You plan on leaving?
No time soon, but I'm just saying. Let's see.
Mr. Corn, you should have received it in the chat.
I did. You guys have a terrific night. Thanks so much.
All right, you too.
You know.
So we're just waiting on Myers and Brunson. And Mr. Houston and Ms. Collins, this is just what I say for you guys. I mean, if I were you, when I would start talking to people, because a couple of these things have came up, like things have happened at the jail, I would say, hey, something comes up, you okay if I waive your presence? Just to kind of keep, I mean, that's just what I would do. But, so that if anything comes up, sometimes emergencies happen at the jail, just what I would do in the future. That way we wouldn't have to try to sit here and wait.
Your Honor, if you reset him, I can visit with him before next Thursday to get him to waive his appearance so we can handle this bond hearing.
I mean, Mr. Collins has 16,000, your guys has 15,500. So we'll give them a couple more minutes, see if they can find them. But, I don't want to keep everybody here all day when I know everybody, I got a full calendar tomorrow, and I'm sure you folks have stuff to do too. So we'll give him a few more minutes till LT comes back on. He can let us know the.
Judge, if for any reason, if I need to reset them, I'll just reset them until Thursday, since we have to reset Ms. Baslin's client. I'll just add them to the Thursday calendar.
I was assured it would be indicted on Tuesday.
No, I'm saying you wanted me to add her
yeah.
case. I'll just add these two cases to that Thursday calendar.
Okay. We'll see what LT says.
Excuse me, Judge. I'm still waiting for One North to contact me for confirmation of Brunson.
Ms. Collins, why do you think that they're One North? Are you working at the jail now? Oh, you're on mute.
The last time I saw him, he was on One North, and that was, I want to say early March. And so I believe that he may be on One North or late February. So I think that he is maybe on One North, and it just says that he's there. Let me get the file.
Let's see.
Yeah, but that's why I believe that.
Okay. I didn't know if you were moonlighting at the jail.
I'll figure it out for sure tomorrow where he's at.
I thought maybe you were moonlighting.
Oh no.
Let's see. Is that what it's saying on Odyssey?
No, on Odyssey it says 4 North or 4 South, I believe. But I'm just trying to give some, that's the last place I visited. I mean, normally when people are on One North, they tend to stay there.
Yeah, last time. Yeah, last time it said they were unable to produce a defendant for so I don't remember why. They have trouble finding him last time.
Yes, they did have some challenges finding him last time.
He wouldn't have to be like on the trustee unit or something, would he? I mean, I'm just
I did check that area and they were not able to locate him there either.
yeah, let's see.
Okay, well, I guess we'll reset it to Thursday and I'll figure out where he is in the morning.
Let's see. Yeah, I mean, we can just, is that okay with you too, Mr. Houston, that we can reset it to next Thursday?
Yes, Your Honor.
So we got these two, we're 1, 2, 3, we'll reset and I think I've already hit send on that email, Mr. White.
Thank you, Judge.
All right, so we'll reset them, these 3 until Thursday, so we'll stick them over here in this pile, and I think that's it, everybody, right? I'm not sure who this Riviera person is.
That's all for me. May I be excused?
Yes, thank you.
Just to confirm, I'm sorry, just to confirm, that was Myers and Brunson. We're resetting to Thursday, correct?
Myers, Brunson, and Witters, yeah, next Thursday.
Witters was Miss Beck's. Okay, Miss Beck.
Right, right. Thanks. You got that, Bustic?
No, I wasn't listening to what you said. I got it.
Yeah, we're gonna reset those folks.
Okay.
All right, Ms. Williams. Where'd Ms. Williams go? You just gonna text me when you got them all in?
Your Honor, I do need your assistance with one before you get off, but I'll wait for everybody to get off.
Okay, what is it?
For Riviera,
Riviera.
number 1.
Let's see.
I still didn't get that correct because in Odyssey, it still brings up the other cases the other charges that's dismissed. So it was
because it has
throwing my
those
count off.
Oh, because it goes
Please ensure that you have your black and white sheets.
because it has it by the numbers.
Yes, ma'am.
So let's see.
So, but just go off the calendar if you can. Give me those numbers off the calendar. And I'll
Here's a
figure it out.
calendar. I'm going straight down the count. You want me to do the chart? I'll just go 3,000.
May I be excused?
Yes, ma'am. I mean, yes, sir. Thank you. Stay healthy and safe. 3,000, 6,000, 1,500, 1,500, 3,000, 500, 500, 500, 6,000, 500, 6,000, 6,000.
Got it. Okay, that was all I needed.
If you text you, I can text. If you text me, I can text you a picture of my. I mean,
Oh no, I got it. I got it this time. But I don't
Okay.
think it's fair that I think you and Bostic are competing to see who can go faster. I just need y'all to slow down just a little bit for me.
I know Bostic talks faster than I do.
But I'll take you in the last orders and thank you.
Okay, thank you. Anything else, Mr. White? Thank you. And I just put you on that email, and hopefully that'll help.
I've got the email, or it looks like I got an email from you.
Yeah. I
I appreciate it, Judge.
Okay.
I believe I don't have anything else for the evening.
All right. Thank you, folks.